She left Lorenz. Okay. Who is girl then? Everybody left. Everybody left. Manoj, he went for breakfast now.
Hello,
Hello, Prasad. ನೀವು ಹೋಗ್ತಾ ಇದ್ದೀರಾ ಲೇಖನ್ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಾ ಓಕೆ ಇದು ಸೆಕೆಂಡ್ ಪೆಟಿಷನ್ ಇವಾಗ ಯಾರು ಮಾಡ್ತಾರೆ ಇದು ಓಕೆ ಮನೋಜ್ ಹೌದು ರೆಡಿ ಇದೆ ಬ್ರೇಕ್ಫಾಸ್ಟ್ ಅಂತ ಹೋಗಿದ್ದಾರೆ ಓಕೆ ನಾನು ಮಾತಾಡ್ತೀನಿ ಎಲ್ಲಾ ನೆಕ್ಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ ಹಾ ಓಕೆ
We have filed in the month of March. The urgency is that some amount is deposited in the trial court. If it is not heard, they will take the amount, so it becomes infructuous. Any date next week, Manoj.
Wednesday.
Obliged.
Any mentioning? List 1. Page 4, number 17 and 18. Page 5, 19 to 26.
My lords, serial number 21, my lords. I'm appealing for the petitioner, my lords, in this matter. I raised for a short accommodation, my lords. Senior is not keeping well today. Can it be have it on the next Wednesday, my lords?
Seniority, Gram Panchayat Secretary.
Please, my lords.
Yes. When do you want it?
My lords, next Wednesday.
Yes.
Much obliged.
Page 6, 27 to 35. Page 7, 36 to 38. Page
My
8.
lord, serial number 38, I am for the respondent, my lord. Arguing counsel is out of station, my lord. Any short accommodation, my lord.
Final hearing matter. Have you informed the other side?
State is up.
State.
Can be. Yes, after a week.
Page 8, 39. List 1, non-compliance first time, 1, Satish K.
Only
Petition.
translation,
Yes.
not the matter pertaining to my lord, the suspension. Lord, the petitioner was working as my lord, the education officer at my lord Mandya. Lord, allegation for placing the petitioner under suspension is my lord, the petitioner has failed to my lord utilize the fund granted by the state government. Lord, the tribunal dismissed my application on the ground that, Lord, I have misutilized the fund. That may not be the allegation, Lord. Allegation is I have not.
So the allegation is also that she has demanded bribe from the principals of government schools.
For
Please,
utilization.
headmaster.
For utilization of the fund.
My lord, she has that is the allegation, my lord, in the charge sheet. She has says that she has also demanded bribe from the primary school headmasters in Mandya district.
The
Therefore,
charge memo is issued.
charge memo is not yet issued.
Charge memo is not issued.
When was
Suspension
the order of suspension?
16/3/2024. Not still
3.
3/2020.
16/3/2024. Still, my lord.
There's only a few more days to go.
Matter has come for the first time, my lord.
First
I have
time.
sought information already. Yet
Please,
to receive instructions.
please get instructions.
Please.
Since there was no,
Office objection is dispensed with for the time being. The learned government advocate seeks time to get instructions. List after 2 weeks.
Please.
Lord, respondent number 3.
3 have to be put on record, put on
Lord,
notice.
1 and 2, my lord, my learned friend appears.
Yes.
Alva.
Yes.
3.
Three also, not three, ma'am.
Not three, my lord.
One and,
Three notice should,
one and two.
Notice to the third respondent.
or my lord, I will take out notice on my lord, Shri Somayaji, BJ Somayaji.
Is
Who-
he a, is he a standing counsel or did he
Yes.
appear? He is a standing counsel.
But he has appeared before the tribunal.
Yes, if he accepts notice,
Yes,
place it on record.
I'll, if your lordship permits, my lord,
Petitioner is permitted to take out notice to the third respondent through the counsel appearing in the tribunal. If he accepts, it is well and good.
Yes.
Otherwise, you'll have to take out.
yes,
18-7.
one,
18-7. Number 2, orders, KG Kamath.
I appear for the petitioner in this matter, Your Lordship. Your Lordship, this one office objection with regard to respondent number 3.
Who's
Yeah.
respondent number 3?
Respondent number 3 is the commission to which I have been because the commission which gave me the gazetted posting, Your Lordship. Your Lordship, before I explain why this particular commission is important in this case, a brief facts about the case.
Please don't bother. The question is only this.
Yes.
Can you make the commissioner party without an impleading petition being filed?
Your Lordship,
Simply made a, the commission was admittedly not a party in the
indeed,
tribunal.
Your Lordship, indeed not.
Without anything further, can you just, whatever it is that you want to say, put it in the form of an affidavit and file an impleading petition. They can object if they have any objections.
I reserve my liberty to file an impleading
that.
application.
Yes, the learned counsel for the petitioner seeks leave to file an impleading petition
Indeed.
to bring the third respondent on record. File an affidavit and petition can be
Great.
considered.
I'll do.
Yes, when do
Great.
you want it? When do you want it? 2 weeks,
A week's time, Your Lordship. I have my
just
client.
after a week.
Great.
Number 3, Sridhar Narayana.
Here for the third respondent.
What is the office objection?
Office objection, in fact, I have complied. Last date of hearing also I made submission. I have translated copy, now I produce it. It may be dispensed with, otherwise again and again it will show in the.
Copy has not
list.
been served. I will take the copies and.
Please serve the copies.
Please,
This was the submission last
Please,
posting also.
please.
last posting, his name was not shown.
For sure. My colleague appeared, my lord, of course. I'll take a copy, my lord, so lordship may consider having it next week, my lord, sometime.
This next week.
Please.
The office objections
Office,
stand complied with this next week. Yes,
please,
Please, great.
any date.
Please. Great.
4, Raghavendra K.
For the petitioner in this case, my lords.
I'm up here.
For the permanent respondent.
8308.
No, no. Serial number 4, that was my notice.
Raghavendra
For the
K.
petitioner in this case, my lords. This is the regarding transfer, my lords, in the change of circumstances. The respondent number 4 is completed the tenure, my lords. And he is continuing the same place. They have filed the objections regarding that also.
Is it for this court to consider that?
Only one submission.
Yes.
Lord. Initially, I will try, he disturbed me. I came to that. The honorable KT issued the stay order, against which my friend has prepared petition. Then
It's an
KT,
interim order.
an interim order that was interim order was granted, subject to final result of this one. Final application, the application was in my favor. Against that order, he challenged that. Now my submission is that by the interim order, I came of this honorable court, I came and reported. I'm shifted my place also. And this way, as such, I'm not interested in blood, maybe close in blood, that my submission. Pursuant to the
Your
Indian law,
contention is that the period is over. Approach
period
the
is over, period is also, I completed my period,
Approach the appointing authority. It is not for us to transfer officers.
No,
Yes, now on that ground, we cannot say that it is, now that who's continuing in the post?
He is continuing in this same.
pursuant to the interim order passed.
Let the state take a call either way.
Yes.
It's not for us to post officers. Can we close this?
Please, I am continuing in the same place, my lords. Petitioner is continuing in that place, my lords. The respondent is continuing in Jayanagar, this thing, my
Can
lords.
be closed.
As per the,
It is with the petitioner, my lord.
State is the petitioner. The state held against these two. Now, my lord, by virtue of the interim order passed by this honorable court, I continued in the same place. I shifted my family. So I also complete my period. I am not interested in continuing the resisting the petition.
The petition is filed against the orders passed by the tribunal on 21/12/2023 in application number 4363 of 2023. It is submitted by the learned counsel appearing for the petitioner as well as the same name as well,
same.
learned counsel appearing for the fourth respondent, that pursuant to interim orders granted by this court, the parties have continued against their respective posts, and that the fourth respondent has also completed his tenure in the post from which he was sought to be transferred. It is submitted that nothing therefore survives for consideration in this writ petition, and the same may be closed. The, having heard the learned gun pleader also, and in view of the submissions made by the learned counsel on all sides, the writ petition is closed, recording
No,
that-
that order has to be set aside, my lords. KT order has to be set aside.
can be set aside. The
KT
KT,
order is in my favor, not that in view of the fact that I continue that it may be closed.
That has to be.
in view of the submissions made on both sides. And after hearing the government advocate also. And in view of the fact that the term of the fourth
Complete in the month of May.
is also complete. The order of the KSAT, which was under challenge before this court, shall stand set aside. The parties shall continue in their present places of posting till orders are passed by the appointing authority in accordance with law.
Great.
Much obliged.
5. Hanumantappa Harvi.
My lord, I bring for the petitioner, my lord. Yesterday matter, my lord, is the suspension order revoked by the appointing authority on 7/2024, my lord. I was on reissued, my lord. My lord, in the absence of non-payment of the service allowance to the petitioner, the proceedings are going on, my lord. At least to participate in proceedings, my lord, by the de-inquiry proceedings. In the absence of the petitioner.
My
a
learned
deed
friend
is
has
going
to
on, my
give
lord.
some clarity on the matter, my lord. What has happened is the petitioner is in the habit of threatening the public as well as the superior officers. Initially, he had threatened a complainant and he tried to forcibly bring about a compromise. Therefore, a minor penalty was imposed on him. And pursuant to that, he called the superior officer who had imposed the penalty and he threatened him. Thereafter, he was placed under suspension. Thereafter, that was challenged before this honorable court, which is the subject matter of this writ petition because it was rejected by the honorable tribunal. Now, subsequently, when the proceedings are ongoing for abusing the superior officer, there is a disciplinary proceeding initiated and that is ongoing.
For insubordination.
Yes, ma'am.
Hmm.
He again posts on in September of last year, February 2024 and April 2024.
Hmm.
On social media platform called Daily Hunt, he posts abusive messages against the Deputy Commissioner of Police, Bangalore West, against whom he had initially abused, who had imposed the initial penalty, a minor penalty, my lord. He says that he is having some illicit relationship with some lady. He says that this person is one IPS officer is going to be murdered within the next 3 months. These are the things he has posted on the social media platform. Therefore, he is again posted under, he placed under suspension by another order, my lord, which is dated 15/6/2024. Therefore,
And the charge memo is also issued?
charge memo is not in respect of the
Last one.
Last,
The earlier
earlier
allegations charge memo was
abusing
also-
the senior officer over the telephone, that is,
that is
proceedings are
charge memo
ongoing.
issue.
Criminal proceedings are initiated for imposing major penalty.
Even if there are multiple suspensions, substance elements has to be paid.
My lord, even those facts have to be properly placed by my learned
It is
friend.
not.
He did not,
placed any item.
his lien was changed from Basvesh Nagar police station to Whitefield traffic police station. He
Hmm.
did not go and report there.
Hmm.
Therefore, his subsistence allowance was not paid because every month he has to file a affidavit saying that he has not
He's
taken up
not
any.
Otherwise employed.
Yes, that he has not done. But that was also going to be paid, but because the financial year came to an end, approval has to be sought from the AG's office.
If you have anything to say, please place it on an affidavit. We'll consider it. With regard to substance elements, if you have any
But that will
contention,
be
please
paid,
place it
I'm
on
told, my
affidavit so that,
Not paid material, not paid, my lord. They're not
please
paid.
place it on record, counsel. Have you reported to the police
But I
that
have,
you were
I have the
posted?
records to say that whenever he has submitted the affidavit, he has been paid. 4 months out of 7 months he has been paid. 3 months he did not report to duty between September and December 2023.
Yes,
To that extent, the copy not put on me, my lord, but D is going on, my lord, it is, in the absence of the petitioner.
you have not filed
That is not
anything
challenged in this.
claiming
petition, only suspension is there.
substance elements in these proceedings. Yes, it appears that amounts have been paid. This is on, which is the month? Month of August 23. Then
August and
January
September, he-
24.
October, November and December, he did not file the affidavit.
But subsequently not paid, my lord, January, February, March, April, May, June, my lord, they have to pay, my lord.
File
Paid.
it.
It's paid.
File it, file an affidavit saying that you have reported for duty and you've not, you've reported before the office to which the lien has been shifted and submitted the affidavit. If you have done so, it has to be paid. File an affidavit. Yes,
10 days time, my lord. Please.
when moved again, you can move it after filing the affidavit. The learned counsel appearing for the petitioner submits that substance elements is not paid during the period of suspension. The petitioner is permitted to make an affidavit to that effect before this court.
My one objection.
This when,
The meanwhile, the allowing the petitioner to participate in the D proceedings, my lord, in my option, they're going on, that's why, my lord.
if
The
you go
principle
and,
of justice.
if
not-
you go and
not-
present yourself, you will have to be heard. It is a disciplinary proceeding.
My lord, in my
Without
option,
you,
sir,
they cannot go on.
going
if-
on, my lord.
You
I
not
guess
been
so.
notified?
Hello?
You not been notified of the date?
We have to participate in proceeding, my lord.
Date is not given, notice is not issued.
Not given notice, my lord. They have to give, my lord. That is why, my lord. The authority shall give notice to me, my lord, to appear to the inquiry committee, but it's still not done, my lord.
Look, I'm
They're
also
depending
told
on
that
the activities of
suspension has been
All
revoked in the month
these,
of.
counsel, are matters which you are raising orally before the court when the matter is coming up. The only contention earlier was that with regard to the suspension, they say a charge memo has been issued. Now, if you have anything to say, place it on record, we'll consider.
Lord, even sustenance allowance, his suspension is revoked in March. Therefore, the question of paying sustenance allowance thereafter.
There was a second suspension.
Second suspension is in, my lord, it is recent, my lord. That is in June, 15th of June.
Of this month.
Yes,
Oh, till then, there was no suspension.
this
From
is
March to June, there was no suspension.
March to June. There was no suspension.
Yes, so place it on record, please. We'll consider.
6, Vijay Kumar.
That relates to lords, the provisional pension of the petitioners, lords. No, lords, they succeeded in application before the tribunal. Only, lord, the tribunal would not have, lord, gone beyond the scope of the order, the prayer, lord. On the last occasion, my learned friend was,
But, it was listed day before yesterday, my lord. The letter went to them yesterday. Not, I've contacted them today morning also. It may be taken up next week. I'll get the
18 months, lord, we have been retired.
When
Till
did they
today, lord,
retire?
no retirement benefits are settled, lord, and not even provisional pension is paid to the
Rule
petitioners.
214,
214A of the KCSR. my lord.
KCSR, please. KCSR. When did you retire?
Lord, first petitioner retired on 31/12/2022 and
After the order of the tribunal.
Lord, yes, yes, my lord. The order of the
Interim order
tribunal is
operating
passed in
against you.
February 2020.
There's an interim order operating.
Yes, my
against
lord,
you.
there was an interim order operating.
Interim order against the reversion from the post
Reversion.
of librarian to the post of SDA and FDM.
Yes.
No, there is an admitted position.
They have succeeded in that.
No,
They have
respect.
they
succeeded.
did not succeed. You have a stay. Even if they did not succeed, it is not as if they've been sent out of service. There is an admitted pension which is payable. Pay them that. Everything else.
I'll
we can
get the
consider.
information. Its letter has gone only yesterday, my lord. I've sent it. The matter was listed for the first time day before
Can we
yesterday.
not direct the payment of the admitted amounts?
Not only the pension, my lord, other,
Why, nothing is being paid.
Maybe taken up.
Nothing
Tuesday.
is been
I'll
paid.
get the instructions and
it's been 18 months, my lord, without even
There's
retirement benefits
absolutely
also
no
not settled.
difficulty. They're only saying that whatever it is that you are admitting, that is payable to them, pay it to them.
kindly have it on Tuesday, my lord. I'll not further prolong this.
The fourth time, my lord, again and again, my lord.
Government advocate seeks further time to get instructions as to what amounts are payable to the petitioners pending the consideration of this petition list on Tuesday.
Please.
That day, you must tell us that either it has been paid or within what time it will be.
Please.
Second good law. 7, Satish K.
Lord, matter pertaining to my lord, retrospective regularization of the service of the petitioners. Lord, there were about 30 my lord geologists who were appointed, lord, including these petitioners. Out of 30 my lord geologists, 8 were given my lord regularization from the date of completion of 10 years of service. Lord, after 2 years, my lord, the regularization given from a retrospective date was withdrawn by the state government. Lord, the order of withdrawal of regularization was challenged before the tribunal. Lord, tribunal allowed the application, quashed, and Lord, the revived the retrospective regularization. Lord, state challenged the order of regularization, order of the tribunal. Lord, the state's writ petition was dismissed, affirming the order of the tribunal. Lord, we were also, Lord, out of 30. Lord, on different dates we have been appointed. They were appointed in the year 1985. We were appointed in the year 1986 against sanctioned post. We have been regularized, Lord, only prospectively. Lord, we approached in the earlier round, Lord, we approached the tribunal. Tribunal directed to consider our representation and pass appropriate orders.
Yes.
No, an endorsement is issued rejecting the claim of retrospective regular, that is, my lord, after completion of 10 years. Lord, endorsement was issued that was challenged before the tribunal. Lord, the tribunal says that we have accepted the order of regularization. Therefore, we are not entitled for.
Your contention is that even juniors had been regularized
Lord,
with effect from the earlier date?
I cannot say, my lord, they are juniors. They were appointed along with me.
Chidananda Murthy,
Yes.
Padmanabha, and 16 geologists regularized.
Yes.
Were juniors to the applicant. It appears to be a contention, not juniors.
It is not juniors. They are not juniors. But they are, may I request my lords to kindly take my lord page 96, my lord. 30 geologists whose service particulars were collated. Out of 30, my lord, 8 were given regularization from the date of completion of 10 years. In this chart, my lord, the petitioners also, their name is also included.
What is the reason for giving only to 8?
But they say that, my lord, as on the date of appointment of those 8, there was a request of the Department of Mines and Geology for regularization. Therefore, we have regularized. My lord, we are not working in the Department of Mines and Geology. We are all, my lord, all 30 are working in the Department of RDPR. Panchayat Raj. The reasoning, my lord, starts from page 56. Tribunal only says that, my lord, we have accepted the order of regularization dated 21/6/2017, which says that it is prospective.
Which is placed A22. Reading the subject as also references
May I
in
read?
preamble of the government proceeding. Government passed order bearing so and so as per the order. So were regularized by the government on following conditions. Same is extracted.
But,
Applicants are unconditionally, without protest, accepted the regularization order dated 21/6/2017. In other words, applicants accepted above conditions and continued their service in the post enjoyed by them.
it is, my lord, tribunal says that we have not challenged the order of regularization dated 21/6/2017. Therefore, delay arises. My lord, in fact, page, my lord, 210, we had approached the tribunal. Tribunal directed after our regularization, my lord, tribunal directed to consider our case.
The regularization was in 2017.
17.
When did you raise your request for retrospective regularization? Immediately thereafter?
Please, my lord. Page 210. We approached the tribunal. Tribunal allowed the application
When did you approach?
2020, my lord.
19, with a prayer to direct respondents to consider representation. 3/12/2017, they have submitted representations.
We had made representation, my lord, on 3/12/2017, and my lord, subsequently, my lord, I don't remember the date, 2018. Those representations were pending before the,
823 is referred to in page 213.
please, my lord.
Representation of the applicants dated 3/12/2017.
Yes, my lord. Then, my lord, the tribunal directed to consider our representation. But an endorsement is issued on 7/1/2022, rejecting our request.
What about others? When did they approach the tribunal? Others?
But they have not, they were given retrospective regularization, which was withdrawn.
Because against that,
They approached, my lord, the honorable tribunal. Order is at, my lord, page 139. At page 139,
lie here, because they've, 823 in the earlier proceeding shows they immediately approached you seeking regularization as with others.
Kindly take this up next week, my lord.
Can we, you can file your objections if you, are there objections before the
not yet.
tribunal?
yes, my
For
lord.
the tribunal?
My lord,
Before the
tribunal-
tribunal, it has.
But before the tribunal, my lord,
Weeks. Because this.
May be
this
taken up
appears
for
to be
disposal.
Factually incorrect.
Please.
That they.
I'll get instructions.
They had accepted it and kept quiet. If they had, what the tribunal says is absolutely correct. If they had done nothing, if they had accepted it, kept quiet, and then come before the tribunal in 2020, what they're saying is correct.
No, even if they, perhaps, my lord, I don't have the benefit of the, looking at the
Yes.
file, my lord, today I have
Yes.
not been supplied with the file. But it appears merely because they gave a representation, they cannot sleep over it thereafter.
See,
Because
did
they
not-
approached the tribunal only in 2020. So because the limitation is
That's
1
not-
year.
That is not the reason stated. All that
Because
is not the reason
limitation is
stated
1
by
year
the
to
tribunal.
file the.
Tribunal says, no, that was allowed. If that was a contention.
The
it would
case
have
was
been
filed in
taken
2020, as my learned friend pointed out.
Lord,
There
my
will
learned
be-
friend is right,
If
my lord.
that is the contention, it should have been taken in those proceedings. The tribunal didn't dismiss that application on that ground. Tribunal allowed. It was directed to be considered. You rejected.
I'll
Then
get
The
the,
tribunal says it is.
I'll get instructions and make correct submission.
Yes, learned government advocate. Takes notice for the respondents.
Lord,
Notice is issued.
notice is issued.
Already issued.
Already.
Lord, it
Yes,
is the
Takes time to get
second,
instructions. It's after 2 weeks.
Please, any date may be given.
Yes.
19th.
Please.
8, Rajshekar, yes.
Please. Office objection is with regard to my lord's production of one copy at annexure A21. Page my lord's 156. That particular document I have produced only to show that my lord's annexure A20 came to be, though dated 20th December 2023. It was sent to me on 30th December 2023 by WhatsApp, my lords. Only for the limited purpose to show that my lords, so show cause notice was, though dated 20th 12/2023, came to be forwarded to me only on 30th of December 2023 by WhatsApp, my lords. Page 156.
Because he was in the habit of keeping his phone switched off. That is one of the allegations. Leaves his headquarters without
what's the-
informing the
what is the
superiors.
post?
My lord,
Deputy Range Forester.
forest officer. He is alleged to have, my lord, he is alleged to have colluded with some people who are
Lords, I'll
smuggling
bring to
wood out of
merits
the
of,
forest. my lord.
merits of the case, my lords, I'll, the office objection is only
Demanded
this,
bribe from these people who are illegally.
my lords, page 156.
Hmm.
Is the document to show that, my lords, the show cause notice which is available at page 149 came to be served to me only on 30th, my lords, only for that limited purpose.
The office objection raised?
Office, same, my lords, I have not produced the typed copy or translated copy of this.
Objection, sir.
Yes.
Uh,
Lords, on
dispensed
so far
with
as
For the time being.
merits.
Lord, it's a proper
Pending
case-
inquiry suspension, my
It's a
lord.
deserving case for imposition of suspension, my lord. He is found to be, I mean, it's not mentioned, my lord. He is also found to be always found to be not present in the headquarters. He keeps his mobile phone switched off. He's supposed to have demanded bribe from people who are illegally transporting wood from the forest.
Lords,
When
all
was the order of
all
suspension?
27th February
2000
2024.
27?
2024. Lords, all these allegations are, my lords, for the first time made by the authorities.
He has been
in my-
suspended previously also, I am told.
Lords, all these second allegations are made for the first time, my lords, in the order, my lords, pending inquiry suspension. Initially, when they served the show cause notice on 2 occasions, my lords, there was no reference or whisper about these allegations in the show cause notice. I can understand, my lords, if they had made a mention about that particular, my lords, allegations in the show cause notice at when they have issued the same in the initial point of time, my lords.
What is the finding of the?
Finding of the
tribunal?
tribunal is, my lords, and now may I request my lords to turn to page
32, my lord. Para
32 onwards,
Hmm. After perusal of the material.
paragraph number 5, my lords. I have perused the amendments made in the application reply statement filed by the state government, documents produced by the applicant via annexures A1 to 27. So also perused the document relied upon by the respondent government, but annexures R1 to R3. And I also perused the decision relied upon by the respondent government, which are referred in the statement of objections itself. And I also considered the oral submissions made by the learned counsels on both sides at the bar. After perusal of the materials produced by both the sides, by way of their respective pleadings and also documents, the allegation against the applicant herein is, though persons are cutting the trees without any prior permission of the concerned authorities, the applicant is not taking any action against them, and he has also not taken any steps for preventing the same. Hence, there is dereliction of duty on the part of applicant which amounts to misconduct. I have perused the suspension order against the applicant, which is dated 27/2/2024. Looking into the suspension order, firstly, it cannot be said by this tribunal that the suspension order against the applicant herein is without any basis and without any prima facie case as against him. In the suspension order, it is mentioned in detail that the applicant is leaving the headquarters without prior permission of the higher authorities. And though he is a responsible person working as a deputy range forest officer, he must have obtained prior permission. Whenever they have received complaints from the public,
Yes,
whenever they have received complaints from the public, and in order to contact this applicant over the phone to ask him to immediately go to the spot and conduct the investigation, it was found that he used to switch off his mobile phone. Therefore, by leaving headquarters without permission and without any availability over the phone, the applicant has committed dereliction of duty. It is also mentioned that when there are cutting of trees in survey number 37, about 50 to
just a
60.
moment, Kunal.
Please, ma'am.
Is that by itself not enough?
I'm sorry. ma'am.
For a range forest officer to leave the headquarters
My
and
lords,
switch off his phone? Answer it in the
We
disciplinary
have,
proceedings.
my lords, answered it. Now, my respect,
Suspension.
no, ma'am,
Have the memo of charges been issued?
Not yet, my
not
lord.
yet.
I've
4 months.
cautioned them that it's already deemed to
Now-
be revoked.
Not done within the next 2
Will be-
months, that is
yes,
the end of it.
Will be deemed to be revoked.
My lords,
within-
may kindly appreciate
Full
here, my
deadline.
lords. Initially, they issue show cause notice alleging that, my lords, I have not taken any action for felling the trees in one private property belonging to one particular location, my lords. They have issued, the allegation is that, my lords, he cut the tree on 8/11. My lords, on the same day, they issue show cause notice to me. I have replied saying that, my lords, we have initiated proceedings for initiation of, my lords, criminal case also against that particular location. Very strangely, my lords, by virtue of annexure A9, the higher officials, my lords, directed me to release that particular tree in favor of, my lords, the erring person. Recording
That
his
case will
statement.
not have any bearing on this
I
matter.
will come to that. Now, that was the first allegation. Second allegation, my lords, immediately after that, my lords, within a span of 15, 20 days, that is on 20th December, they issue one more show cause notice saying that, my lords, I have not taken any action against, my lords, the persons who have felled the trees, my lords, about 40 to 50 or 50, my lords, trees by issuing the show cause notice. I reply them. Thereafter, my lords, by an order dated 27/2/2024, my lords, even before taking any action, my lords, there also in the while issuing second show cause notice also, my lords, I have contended that criminal cases are, my lords, lodged against the persons.
It is a order of suspension.
Please,
And whatever be the facts of the case, those are to be examined in the disciplinary
please.
proceedings.
Now,
You are aware of the
yes,
the
yes.
limitation with regard to the
Yes,
exercise
yes.
of jurisdiction against an order of suspension issued if there is something to indicate that there is some allegation against you. Is all that is
Now, my lords, my
required.
respect,
It
my
should not
respect.
be exercised mechanically, it should not be exercised mala fide. Apart from that,
This is by virtue of, my lords, mala fides is my respectful submission, because, my lords, on 8/11, when they say, my lords, these allegations were not there. And when they, my lords, issue second show cause notice relating to the second allegation, my lords, there also there was no whisper about these particular allegations. For the first time, my lords, in the official order itself, they have said, my lords, suspension order itself, they have said, you have the habit of switching off the phone and you have the habit of.
as a matter of fact, that is true. That by itself is bad enough for a suspension as well as for initiation of disciplinary proceedings.
My lords,
If an officer who's so responsible, a deputy range officer, goes out of his office, switching off his mobile phone, that indicates it is intended for some other
it's
purpose.
not
Why
even
else?
not even prior incidents.
So, all those are matters to be examined in
That's
the.
now, my lords, already 4 months are lapsed, my lords.
Yes,
Twen-
therefore,
27
they don't, will
27
wait for the required time. If they don't do anything in the meanwhile, you are entitled to a posting.
Lords, 27/2 is the order.
No specific allegation of malafide has been made in the application before the tribunal.
Yes, the learned government advocate seeks time to get instructions. Please tell us whether the charge memo has been issued or not.
Not yet issued. That's
Just after 3 weeks.
I've cautioned them that this will happen. It will be deemed to be revoked within
Have
6
to
months.
be,
I have
be-
informed them.
deemed revocation is the moment the 6-month period is over. Even if we do nothing, that would be the result. Yes.
I seek for
3
date,
weeks.
date, my lords.
Date. 3 weeks.
Please.
22nd, 23rd,
16th.
3 weeks ಆಗ್ಬೇಕಲ್ಲ 19th could.
Great.
9, M. Nagarajan.
Appeal for the petition, Lord, please. Lord, there is an office objection, Lord, that Annexure A8, Lord, instead of producing a correct copy before the tribunal, it seems that's a mistake. Now I cannot correct the mistake what has been committed before the tribunal, Lord, that I may be permitted to change this way, Lord, that. Annexure A8, Lord, I referred in a letter dated
Annexure A8.
page number 50, Lord, page number annexure A, page number, a true copy of the letter dated 17/7/2000, addressed by the responsible producer annexure A8. In fact, that was not produced because some other document has been produced, an order passed by tribunal is produced. I cannot now correct that mistake, Lord, that I may be permitted to produce by allowing the separate. This note that is not relevant for the purpose of this case. Presently.
Yes.
There. Then
Petitioner is
No, one
permitted to
submission.
produce a proper copy of the annexure A8, which he seeks to rely on.
Yes. The matter pertains to induction of an state forest officer to Indian Forest Service, not that. Now, under Rule 5, from the year 2008 to 12 onwards, no proposal was sent by the state government to the selection committee meeting for partner. Now, subsequently for 2012 to 2020, for 8 years, at a stretch, they've given that. Now, the selection committee considered my case for selection for the year 2016. I was selected with selection committee. Then pursuant to that, the government, the issued your order also by state second respondent Ministry of Forest also issued that. Then at the time of issuing the notification, you said that I was not issued the appointment order on the ground, by that you retired from service. This was a coordinate bench of this on the Central Administrative Tribunal has said that retirement will not come in the way of interest for the relevant year of that year. Now, Ernakulam bench of this all the CH-3 also that had that. Pursuant to that, not those persons, those who are retired from service, they were appointed. I have the copy of the notification on that. But this tribunal, this tribunal, disregarding that two judgment coordinate bench of this Bangalore bench and the Ernakulam bench, has held that decision that since you are retired from service, you are not entitled to be inducted. The endorsement I have given a representation, the endorsement given that there is no enabling provision in the rules to promote you from 2015 like that. Now they having issued a similar order has been similar orders has been complied by the ministry. Now they cannot close it like that.
Yes.
Lords, I appeal for respond number 1 and 2, my lords. My lords, the period between which it was not sent was due to the reason because there was some dispute and there was a case pending before the Honorable Supreme Court, my lord, with regard to the SC/ST reservation.
Seniority. With regard to seniority, as to whose names to be sent.
There was, with regard to that, my lords. After that, my lords, the state government sent it in the year 2022, my lords, and it was considered. By that time, my lords, he had retired in the year 2019 itself. So those persons who were there in the service, my lords, because they have to be in the state service, my lords, when it has been considered, and it is not thing which it is like a promotion or anything. It is like a new entry into the IFS.
That is true. But those persons who were actually in service as on the
They were given.
date, they were given.
They were given. He
Now,
was
the
not.
contention is that even in cases of others who had retired by the time, other benches of the tribunal have directed the.
Lords, even that contention was dealt by the Honorable Tribunal, my lords, and it has rejected by giving reason. Even that it is done. I'll just point out that.
Anyway,
That was not the stand up.
Now,
No,
notice
that
as
was
to
not
go
the
for the other respondents. I appear only for 1 and 2, my lords. Others are there.
You are the.
Why was it not sent would be the one question. Second would be, what would be the effect of it being granted after he retires? And he contends that there are other, please tell us what that is, that entails. Learned.
Looks, I appear for 1 and 2, my lords.
CGC takes notice for our 1 and 2. Learned government advocate is directed to take notice for respondents. 3 and 4. Don't have a copy.
Yes, state government advocate.
Please serve a copy.
Please.
3 Three is the Union Public.
Only,
Works
only I have to
Commission.
send
You
for
are supposed to
UPSC
get
only.
right.
Notice has to go. I can't take it.
Government advocate
Okay,
takes
good.
notice for respondents 4 and 5.
Only UPSC notice, my lord.
Notice to the third respondent.
The UPSC has also recommended my name, Lord, that my name was already in the list, please.
Consider. Yes.
Much.
Please serve copies.
Please, a date may be kind of short, madam, Lord, please, unless it is independent to the court, please.
3 weeks.
23rd,
Great.
11,
Lord, in this matter, I beg to appear for the petition. Lord, please, sir. Now, the petition, there is a legible copy is not, the legible copy is not in Kannada, Lord, that I furnished a translated copy of that. That is also not relevant, Lord. I furnished a translated copy, only the, what is there in Kannada that is not legible to. Please. I concede the fact that it's not legible, Lord, but I certainly have furnished the translated copy of that.
Is it objected to? Can be. Yes.
Lord, only.
The since copy of the translated copy of annexure A13 is produced, the office objection is overruled for the time being.
Only one submission, Lord. The petition is a Indian Forest Service officer. He was kept under suspension by an order dated 21/3/26/2023. That was challenged before the Honorable CAT Bangalore bench. That by referring to the rule, Lord, the rule which occupies the field, what he stated that not that charge shall be drawn up. That shall be the basis for whether the desirability or necessity of keeping an Indian Forest officer under suspension. Admittedly, not as on the date on which I was placed under suspension, no charge sheet was drawn up.
Yes.
The matter was went on, not till then on 19/3/2024, the matter was reserved for order source. On that day also, the tribunal, honorable tribunal put a specific question whether you have put, they said it was not drawn. Now, not subsequently on, it seems that not subsequent after the matter is reserving for orders. The London government, central government was appeared for the state government produced the certificate which was charge memorandum dated 21/3/2024. Then subsequently on 23, this was.
Please show us the rule. It
Please,
says
ma'am.
that it-
Yes,
please show us
I'll.
the rule.
To page 211, please. Rule 240, relevant portion, the rule 3, page 214.
Yes.
Suspension. If having regard to the circumstances in any case, and where the articles of charges have been drawn up, the nature of the charges, the government of the state or the central government, as the case may be, is satisfied that it is necessary or desirable to place under suspension a member of the service against whom the disciplinary proceedings are contemplated or are pending. So what is that? Not that article in any case and where the articles of charges have been drawn up. So admittedly, not till the date on which the matter was reserved for orders, the articles of charges has not been drawn up.
Just a moment. Then what is the meaning of the second proviso?
Second proviso also not that.
Read it further. That
Yes,
where a
yes.
member of service against whom disciplinary proceedings
so-
are contemplated is suspended.
Yes.
Such
Yes.
suspension shall not be
I
valid.
come to that. Provided further, where a member of service against whom disciplinary proceedings are contemplated is in suspended, such suspension shall not be valid until before the expiry of the period of 90 days from the date on which the member was 30 days.
Please tell us when were you suspended?
Who suspended?
Suspension is on
That
21st
was
June.
not done. That was not
When were you suspended?
my submission.
When were you suspended?
21st June 2000.
21/6/2023. Now this fact, I brought it.
It's 23.
Please. There was an interim order of stay also, my lords, in this matter.
No, English 1 minute.
Therefore, from the date of suspension, within 90 days, if the charge is not drawn up, what happens to the suspension?
It shall not be valid. That is the rule says that.
Then, after the charges are drawn up,
Right.
you probably are able to pass a fresh order of suspension. That is another matter. But the earlier suspension goes.
There was
with
an interim
date
order.
of 90 days.
There was an interim order of stay granted by,
Even if there is an order.
Is there?
Even if there is an order, that will not make any difference. Those are judgments of
No,
the
no, order of
of
suspension
the
is
apex court,
160. Order of suspension is by state government,
State
not by
government.
friend.
whoever it is by. Unless the charge memo is issued within the 90 days, that suspension goes. Then after the charge memo is issued, probably there can be a further order of suspension.
In this
My
matter,
learned friend appeared in the matter. for the
in this
tribunal.
matter, my lordship, first instance, my lordship, tribunal is not granted the interim order on the suspension. Against which my lordship, we filed a writ petition before your lordship. This honorable court, my lordship, granted the interim order. That order is, my lordship, not,
No,
no, earlier proceedings.
It's not a case, because there is not a suspension which is passed in contemplation. If it is passed in contemplation, then the charge memo, because it is in contemplation, the charge memo has to be issued within. It is not considered.
Contempt ಹಾಕಿದ್ರು.
Because normally it is
tribunal order is to be included.
like in the state.
247.
In proceeding is taken,
247.
also is only an exception. Contemplation also you can raise an order, person under suspension. Only contention is that it has to be. What would be the effect of the order of stay?
Order same now, this
Let's see.
honorable, what happened, Lord, that initially approached the
Did a writ
tribunal.
petition.
Initially I approached the tribunal did not grant the interim order. I approached this honorable court granted the interim order, making clear that interim order will be in force only till the final disposal of the OA. OA has been dismissed, making clear the honorable High Court has granted the order only disposal of the OA. Now the OA has been disposed of, therefore this order gets revised.
That time this court granted interim order, 90 days had elapsed.
Which one?
By the time this court granted interim order,
Till disposal of the OA.
no, by the 90
When
days.
was the,
No, now, Lord, the grant of stay order will not come in what is the rule say? The grant of an order which is in force will not come in the way of doing the revival.
This court granted interim order.
when was the interim order granted?
1 minute. Interim order, I said, they are produced in the impugned order itself, it is stated, page number 248 is the impugned order. Page.
1/7/2023, Manoj. 1st
1/7.
of July, 2023.
Will that as a matter of fact make any
Sorry,
difference?
it is 18/7/2023.
Whatever that be, please tell us what would be the effect. Has that been considered in the impugned order?
On consideration of the order, my lordship, we filed a contempt before this honorable court. In contempt, my lord, in contempt proceedings, we accommodated social forestry for that
No,
post. my
that,
lordship.
I'm not.
That is accepted by the
I'm not on.
petitioner. That is accepted by the petitioner. My lordship, then contempt is closed. Now, my lordship, only matter is pending before the tribunal till consider the final disposal of the OA, that interim order will continue.
Question is not any of this.
This one.
It is simply that whether an order of stay granted by this court would absolve you from the responsibility of issuing the charge memo within 90 days of the date of suspension. Will it or will it not?
That is in.
Is that considered by the tribunal?
Yes.
Where
CH order court ಮಾಡಿಲ್ಲ.
Page 264. Page
the provisos
264.
haven't been seen.
Interim order. CH order.
Where is the proviso noticed by the tribunal?
Provision has not been, those was brought to the notice, it was not noted, it was not discussed. Second, what that it was that only rule 3, it has stated that it has two parts, the state government has kept them under suspension. to part charge, member, issuance of from memorandum of charge is not mandate. It goes against the judgment of the Honorable Supreme Court in case RP Naik, not what they say that. As on the date when I approached that
Just a moment.
CH order change ಮಾಡಿದ್ರು CH order. ಇದು ನಾನು CH order report ಮಾಡಿದ್ರು ನೋಡಿ. ಇಲ್ಲ CH order report ಮಾಡಿದ್ರು ನೋಡಿ.
What is your answer on the proviso?
That is our, in reply, we taken the clear stand, my lordship, matter is contemplated. As per the second proviso.
Is contemplated,
Please, my lord.
then the charge memo should be issued within 90 days.
Is,
Have you done so?
no. We are not.
Admittedly
issued the-
not, my lord.
Not issued, because my lordship, some inquiry is going on.
Tomorrow is to be granted.
Now, I will get instruction, my lordship, kindly fix the date and final disposal. Because serious allegation is there.
Proposal,
No,
please.
because serious allegation is against him.
Serious allegations are other things, counsel. Please tell us, have you complied with the provisions of this, of the rules?
Report ಮಾಡಿದ್ರು
That
ನೋಡಿ.
is
Has
also,
it been done?
I will explain, kindly fix the date, my.
No,
Thing to explain. Please tell us, has it been done or has it not? As a matter of fact, the order of suspension is on 21/6/2023.
That is tribunal.
Has
is-
the proviso been noticed by the tribunal?
That I place it
As
with some
it has-
judgment before the tribunal, my lord, once the matter is contemplated, the honorable apex court, my lordship, that is if the, my lordship, in you are extended that suspension order, there is no bar for my lordship delay in
There was an order of extension?
no
No.
extension is also no there.
no, it was.
But I will, I place that judgment.
Hello, only one submission. Your Lord may kindly page number 284, the operative portion.
Tuesday?
Not Wednesday.
No,
Tuesday.
only one submission. Page number 284, I'll make kind with that. The order,
This is
page
first
number
time, my
two,
lordship, you not.
1 minute, please, I'm still.
Yes,
Page number 284, ink page.
yes.
The order of interim stay against the suspension of the applicant by the Honorable High Court of was only till the pendency of the present application. Since the present OA has been dismissed, the interim stay against the suspension ordered by the Honorable High Court ceases to be operative. Now, my lord, the rule says that
This
if
is
it is
dated.
not done, it becomes
This is on
invalid.
Wednesday.
This is
Now
dated. This order is
It's
dated.
on 23/4/2024.
yes, ma'am.
You've been remaining under suspension after that?
No, I've been, no subsequent inspection. I've been continued in duty only, please, not that. No, unless this order is being said, on the strength of this order I'll be again kept on
Present
suspension.
place.
Right now, under
Posted to
training.
some other place.
So therefore, my,
Instead of this present place, he posted to some other place.
He's
Now
working
he is
there.
reported the
Uh,
duty.
Working there? Yes.
last may kindly, my prayer is to
Heard
say
the
the
learned
operative
counsel
portion of
for-
the
The learned government advocate seeks time to get instructions and to place arguments on record with regard to the drawing up of the charges within 90 days from the date of order of suspension. List after 3 weeks. In the meanwhile, status quo as on today with regard to the service of the writ
Sure.
petitioner shall be maintained.
No, he is already, lordship, in duty. This, this-
the now
Waiver of the suspension will be
the
stayed.
the tribunal gives a direction, Lord, which amounts to keep, it amounts to issuing a direction to an officer, to keep an officer who is already suspended to suspension. It gives a further direction to keep him under suspension. Therefore, by humble submission to Lord, with
Did you, as a matter of fact, rely on the proviso before the tribunal?
no, I specifically point out second proviso. As on the date, I can't achieve second proviso.
Was it argued? Because it does
Well,
not appear to have
I
been-
produced the rule. They did not even whisper to the rule in the tribunal order.
Para 27, it is referred, my lords.
Para proviso, what is referred? Proviso is not referred. Not referred.
It is mentioned, my lords.
appear to have been argued.
Pramod, it's not your bill. He is my friend has argued. It was not your case. He was very much.
Posed the question, I tried to answer, that's all, nothing against.
Only when the applicant poses a question, they need to answer. They need not answer questions which are not posed either by the applicant or by the tribunal. Yes, anyway.
Great, great.
Just a minute.
3 weeks.
Three or four.
Later.
Third.
Third.
3 weeks. 3 weeks, let them get
23/7.
proper instructions in the matter. No, they've also not placed him under suspension after that or implemented the order.
My submission is that the tribunal goes against as a legislative delegate registration, it goes not that you did that. Instead of specifically showing that the specific question fall to my friend is, why did you not issue that? Why did you not issue that? Then afterwards, at the instance of the tribunal, my friend issued a notice, his memorandum of charge on 23rd.
Seems to have gone on
Great.
other tangents. The proviso and what its effect would be, whether the stay would have any effect on the dates.
It
nobody
has,
has
they
considered.
did not, admittedly, they did not do that.
Yes,
CST for R1 government.
yes, please, please.
Then, M. Nagaraj,
Listen, matter, a bit up here, sorry. The Kannada translation, not that those documents are also not relevant, please. Whatever the relevant document necessary, I produced that.
What is the issue?
The issue is matter of suspension. The is a executive deputy Tahsildar, working in the office of the Tahsildar Nanjan Gold that. He was placed under suspension on 4 allegations and all that. Only that, the first allegation is that I have certified a document which has been signed by the village accountant, number 1. Number 2, you have issued a Pauti Kata, which is a Kata with interstate success. Third one is that you issued a genealogical tree. Fourth one is you have not replied to the
Just a moment, counsel. When was the order of suspension?
order of suspension. Is not
24th January 2020,
24/1.
24.
Memo has also been issued.
Charge, but the matter is listed for the first time.
Please get instructions.
Please.
As a matter of fact,
It has
memo
expired.
has not been
6
issued,
months
then
is,
there is deemed,
I'll get in.
memo has been issued to you.
No, not it. Not it.
25/1.
Maybe taken up on Wednesday. my lord, I'll get in.
Only one
Next.
only one submission. Lord.
Yes.
Now, I had the benefit of the interim audit was honorable tribunal. For more than 3 months, I was working there. Subsequently, while dismissing that order, they say judgment that I had benefit of that. Now, what the purpose?
When was it dismissed? When was the OA dismissed?
My lord, 14th June 2024.
14th?
June 2024.
Page 77. Lord.
Page?
In page 77.
No,
Sorry,
this is
sorry.
Their application.
No, page 18, Lord, Annexure C. Annexure C.
17010.
7010.
Because in that case, it is 2019.
Sometimes it happens. Lord.
Annexure?
Annexure C, in page 80. I was kept under suspension on 24/1/2024.
15/6/20. Annexure C also.
Date of the impugned order is not.
Sorry,
Date of the
sorry,
impugned order
sorry.
is not in page 80,
Yes,
dated 14 June 2024.
yes.
I was placed under suspension by the order dated 24/1/2024. On 2/2/24, the Honorable Cabinet was pleased to say the operation and implementation of the order of suspension.
First delegation.
I had the benefit of the,
Scope of interference. Says following division review on matters related to central food service pending disciplinary inquiry. Is it actually pending?
My lord, was listed for the first time. So, my lord, the
Only
petitioner may
one
be
second.
directed to report to the competent authority, my lord. Because he is required to report as per the rules,
If
6 months
charge
after
memo-
the expiry of 6 months.
Charge memo has not been issued within.
If charge memo has not been issued,
It had not been.
not it, charge memo has not been issued, my lord.
it has not been issued. So he has to report as per the rules, my lord.
Heard the learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner that the order of suspension was dated.
24th
24,
January.
1/2024.
Order of suspension was dated.
24, 1/2024, 24th January 2024.
1/24, then 6 months is not over.
It was, yes, my lord, that
For 1 month. So this is June.
is June, my lord, that,
On 24th June, it has expired, 6 months.
24 July it expires. 24/1, no? 6 months have to
no, we are in the month of June, my
Expire in
lord.
July.
July.
expire only in July.
Yes.
There is
Yes.
time. Please get instructions. by the
I'll get
learned-
Only one submission, my lord. I had the benefit of this interim order by the,
That will
I-
not, it is
I
not the
work-
first
I
appeal
work-
council.
I
Let
work
them,
for-
please let them get instructions in the matter next week.
no, only one more submission, my lord, that I worked for 6 months, my lord, but yes, on the strength of the impugned order. Now they are making hectic arrangement to relieve me from, my lord, that is my submission, that's all. Now, having worked for 6 months, my lord, that
Some early date may be given. I'll get instructions and assist the court to.
only,
This
they may
chapter-
relieve me, my lord, that, they may relieve me, my lord, that.
1 and 2. I'll accept notice for respondent 1 and 2.
Please don't relieve in the meanwhile. In the meanwhile, don't do anything.
I'll,
Next week. Yes.
please. Bye, sir.
A short date may be kindly become fixed.
5/7.
5/7, great. 5/7. I'm extremely touched. I'm extremely sorry to make a submission. I will just now, but in section has been yesterday reviewed of that. I may be permitted to continue in that portion of that. First, when you have the dismissal.
I'll
I may
inform them.
permit- I may be
I'll
permit-
inform them until the,
Let there
not
be order.
precipitate the matter until the next statement.
Yes.
I'll inform them.
Let that be ordered, I may be permitted to continue, blood, please. Let that be ordered, madam, please. I worked for 6 months, blood, the charges, I did not issue any material, I put that they accepted them.
All that is on the facts of.
That's a matter of inquiry,
Not for,
I bowed down, but I may be permitted to continue, blood, please.
But because it will be taken up very soon, my lord. I'll get instructions. I'll inform them.
please inform. Yes.
May ask for, I may permit to continue, blood, please.
Let that, they say that it will not be done.
No, yeah,
Please-
I was just now. This is
Please
message.
take your,
Yeah,
yes.
yesterday they are relieved, Murad, that's what I'm telling them. I may permit it to continue. I'm not saying, I'm not may.
My lord,
I
can
can
it be
be honest
passed
with
over?
the
I'll,
court.
my lord, can it be passed over? I'll get instructions.
Yes. 2:30.
Please, ma'am.
Well, Rangnath S. Joyce.
Appear for the petitioner.
Yes.
I appear for the respondents in this case, please. This has a checkered, this is a connected case. This has a checkered career. In all the proceedings before as before the tribunal and as before this honorable court, and ultimately the matter reached Supreme Court. In all the forums, we are successful. The matter is like this. One name, the matter is like this. This pertains to this pertains to a class of persons, government employees, the lowest rung servants. That is, sorry to say that, ನಾನು ಕನ್ನಡದಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಆಗಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ರೆ ತಾವೇ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ. ದನ ಕಾಯೋರು ಈ ಯಾವುದು ರೇಂಜ್ ಸೇರ್ವೆಗಾರ್ಸ್ ಅಂತ ಅವ್ರನ್ನ ಹೆಸರು ಸ್ವಲ್ಪ ಹಾನರರಿ ಆಗಿ ಇದರಲ್ಲಿ ಸೇರ್ವೆಗಾರ್ಸ್ ಅಂತ ಕರೀತಾರೆ. See, they were all appointed on a petty sum.
Yes.
Just 1 day, 1 month ಗೆ 1 rupee, 2 rupees then. ಅಷ್ಟೇ ಅವ್ರಿಗೆ ಅಪಾಯಿಂಟೆಡ್ ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ಅವ್ರು ಕೊಡ್ತಾ ಇದ್ರು ಮಾಡ್ತಾರೆ. They served in that fashion for the law for nearly 40 years. At one point of time, the government, the pressure mounted on it, and then they got the benefit of regularization under the judgment of Dharwad daily wages case,
Yes.
2000.
Yes.
Then, not subsequently, that Dharwad daily wages got, even though passed an order in our favor, benefit has not been paid to us. We are entitled to be absorbed.
That judgment was overruled in Umadevi?
No, sorry. That is the information supplied by the other side that that judgment has been overruled. Let them show. Let
Please.
them show the concrete evidence. But your honors may kindly appreciate, my lords should appreciate,
It is available in
That-
the judgment, we'll just.
There are 20.
it is still, Uma Devi's case is still in vogue, still on the field,
Umadevi is.
still Uma Devi's case.
Yes,
That has not been overruled.
yes.
Only thing is,
Dharwad case has been overruled.
I have
in
no
Umadevi.
information, but I verified, but
Paragraph 20 of Umadevi.
20 of
ಯಾವ್ದು?
Umadevi. Paragraph number 20 of Umadevi.
ತೋರ್ಸು.
ಇದೆ ಸರಿ.
ಏನಿದು?
Paragraph number 20 of Umadevi.
Para number 20, please, please.
Yes,
Yes. May I read, please?
yes.
The decision of Dharwad District PWD Literates for Daily Wages Employees Association and others versus State of Karnataka, so and so, dealt with a scheme framed by the state of Karnataka, though at the instance of the court. The scheme was essentially relating to the application of the concept of equal pay for equal work, but it also provided for making permanent or what it called regularization, under a process of regularization, without keeping the distinction in mind of the employees who had been appointed and appointed on ad hoc, ಈಗ ಇನ್ನು ಸ್ವಲ್ಪ ಓದಪ್ಪ ಇಲ್ಲ. Casually, sorry, I have got some.
Casually, temporarily.
Casually, temporarily, ಎಲ್ಲಿದೆಪ್ಪ ಅದು?
Casually.
Temporarily or on daily wage basis. In other words, employees who had been appointed without following the procedure established by law or for such appointments. This court at the threshold stated that it should be individualized justice to suit a given situation with respect to it, or not possible to accept the statement unqualified as it appears to be. This court is not only the constitutional court, it is also the highest court in the country, the final court of appeal by the virtue of Article 141 of the Constitution of India. What this court has laid down is the law of the land. Its decision are binding on all courts. Its main role is to interpret the constitutional and other statutory provisions, bearing in mind the fundamental philosophy of constitution. We have given into ourselves a system of governance by rule of law. The role of the Supreme Court is to render justice according to law. Is one as one jurist puts it, the Supreme Court is expected to decide questions of law for the country and not to decide the individual cases without reference to such principles of law. Consistency is a virtue. Passing orders not inconsistent with its own decisions of on law is bound to send out confusing signals and usher in judicial ethos. Its role, therefore, is really to interpret the law of law and decide cases coming
Before it,
Elpa?
coming
before it according to law. Orders which are inconsistent with the legal conclusions arrived at by the court in the self judgment not only create confusion but also send to assure in arbitrariness, highlighting the statement of arbitrariness, highlighting the statement that the equity bends, equally tends to vary with the chancellor's foot.
Now can we go to paragraph 54?
Kindly, Miller, kindly
Just a moment.
turn to,
Can we
Huh?
now go to paragraph 54?
54.
Please.
Paragraph
54.
50. Oh, yes. I was about to show to your lordships. 53. Let us read from 53 onwards. Yes. Copy ಕೊಡ್ತೀರಾ ಸಾಹೇಬ್ರೆ? Mark ಮಾಡ್ತಾ ಇದೆಯಲ್ಲ? Okay, fine. I am reading 53, paragraph 53.
Yes.
I have marked it. One aspect needs to be clarified. There may be cases where irregular appointments, not illegal appointments, as explained in S.V. Narayanappa or in Nanjundappa Supra, Nanjundappa and B.N. Nagarajan Supra, and referred to in paragraph 15 above of July of duly qualified
Duly qualified
persons.
Sanctioned
Persons.
vacant post might have been made. And
I pray your
employees-
lordships, let
Yes, yes,
let
please.
my friend read. I am finding it so
Please.
little difficult. Please.
Of the duly qualified persons in duly sanctioned vacant post might have been made and the employees have continued to work for 10 years or more, but without the intervention of order of courts or of tribunals. The question of regularization of service of such employee may have to be considered on merit in the light of the principles stated by this court. The cases above referred to the light of this judgment. In that context, the Union of India, the state government and their
Instrumentality.
should take steps to regularize as one-time measure the services of their instrumentalization should be taken steps to regularize one-time measure service of such irregularly appointed who have worked for 10 years or more in daily sanctioned post
but not under cover of orders of courts or tribunals, and should further ensure that regular recruitments are undertaken to fill those vacant sanctioned posts but required to be filled up in cases where temporary employees or daily wages are being now employed. The process must be set in motion within 6 months from this date. We also clarified that regularization, if any already made but not subjudiced, need not be reopened based on this judgment, but there should be no further by passing of such consequential
Bypassing,
constitutional,
bypassing of the constitutional requirement.
Permanent those not only appointed as per the constitutional scheme.
Please read 54 also.
54. It
Please.
is also clarified that those decisions which run counter to the principle settled in this decision, or in which the directions running counter to what we have held herein, it stand of their status as precedents.
Precedents.
Yes. Will stand denuded of their status as precedents.
Yeah.
Therefore, whatever is said in the Harvard case, which is against what is stated in paragraph 52 and 53 of Uma Devi, will not be a precedent anymore. It cannot be relied on for any purpose.
We cannot take in that fashion, with
The only
great respect.
fashion we can take it in council. Yes, sorry.
With great respect. My lord, your lordship may kindly see, ultimately, this very same Supreme Court has dismissed all the cases pertaining to the same subject. Appeals filed by the
Council, it is open to council to argue against constitutional bench decisions.
Please.
It is not open to the court to accept any such contentions. We are bound. Bound in all respects by judgments of the constitutional bench. We cannot, it is open to council. Council have the freedom to argue. We, however, we do not have any such freedom.
With
Yes.
great respect, we are. Judges.
Yes, we understand the contentions,
Please, please.
but like we said, we are bound.
Hold.
We cannot exercise equity against what is laid down by the
Please,
apex court.
please.
We cannot exercise equity as against what is laid down by a constitutional bench of the apex court. We are bound.
That fact is, I do agree with your lordships, but only thing is, I tried to make a distinction as between the judgment passed by the Supreme Court and this. My lord, I am entitled to, my lord, I
But
can.
you are persons who have been granted the benefit of the 2013 Act. You have been granted fixity of tenure.
No, not these people.
Yeah.
This is the second connected writ petition. They, I believe, retired. They retired prior to that date.
It was only those persons who had actually been regularized on the basis of the Dharwad case and the scheme frame there, and
Please.
who would be saved. Nobody else would be saved.
Even
To
Your lordship-
contend that you are entitled to the benefit of the scheme framed under the Dharwad case after the Uma Devi's case would be a futility. We cannot do anything.
May I submit in this regard, my lord?
Yes,
Last occasion I have submitted the arguments, only legal aspects now I am submitting because
yes.
your lordship have come to the prima facie conclusion that after Uma Devi, Dharwad judgment has been denuded. That legal concept that as a precedent, Dharwad judgment has become is no more good law is accepted. I don't want to argue because the constitution bench has said so. I can't go beyond that. But thereafter, very Supreme Court in a particular facts of case, what has done is before your lordship, and what division bench of this honorable court in those circumstances has done is before. So facts of this case are This, my lord, your lordship may kindly let me point out why we are submitting. After 6890 was issued for regularization, there was a mandate on the state in pursuance of the judgment that these are the persons who are eligible for regularization, mode of regularization, everything was prescribed. I have produced those government orders along with the memo for filed on 3/10/2023, my lord. I have filed a memo for IFR disposal. In that, I have produced 6890. And thereafter, one more order, my lord, 1994, 20th October 94, annexure G1, my lord. Because the state government
Just a
had
moment.
failed.
Just a moment.
He's sailing with us.
Yes,
My lord,
yes.
Sir, you're not audible.
Kannada translation, Kannada to English translation, and go order is there. Once again, the state government said there are several cases which are left over 6890 you have not done. So all those cases we have to be regularized if they are appointed prior to 1784. Is annexure H, my lord, 29994 is another order issued in respect certain engineering graduates or diploma holders who are not appointed against the sanctioned posts in the Department of Public Works, my lord. They were just appointed as graduate engineers and diploma engineers. They were not. So those cases, the government itself clarified on 29/9/94 that their cases also fall under 6890. So on that basis, my lord, thousands of persons have been regularized from 1994 till the 2006 Uma Devi case. Then my right to be considered under the government order of 6890 and 94, their claims, the government uniformly did not pass in any order for all people. They were just taking individual cases and regularizing their cases, my lord. There were several leftover cases, my lord, whose cases were not considered. Then, my lord, a batch of persons had approached the Honorable Supreme Court, my lord, in the case ultimately resulted in 2014 volume 13 SCC 249, my lord. Page number 138 of the very same IFR disposal, my lord. I have produced a division bench judgment of this honorable court, division bench. It is, my lord, division bench judgment accepting Supreme Court judgment in respect of persons who are left over. Page number 138. Or 78, I think so. Annexure K is the judgment, division bench judgment, which extract the Supreme Court judgment. Annexure K, my lord, annexure K, along with the IFR disposal.
IFR disposal.
But that is division bench, my lord. His lordship Sujata and Rachaya, division bench, my lord. Dated 10th November 21, annexure K, where the state seek to challenge certain regularization already ordered by the tribunal. As against which, my lord, tribunal has allowed the application that those cases who are not considered under 6890 pending cases shall be considered. Tribunal allowed the application. Against the state came in appeal. And annexure K is the order, an elaborate order considering all the government orders, Supreme Court judgment, Uma Devi's case, and also, my lord, the judgment of the Supreme Court.
When did you approach the government for regularization with your details?
My lord, there was a mandate on the state to regularize their cases. So far as we are concerned, as already, my lord, don't want to repeat it. I had already approached the tribunal in earlier occasion, which I said. That is at annexure, in the main writ petition at annexure, page 30, annexure A1.
Yes, we'll consider.
That order culminated in a direction, because those days, because Umadevi came, they were not considering at all, my lord. Just say Umadevi is there, we were not considered. Therefore, I was forced to approach the tribunal in the earlier round of litigation at page number 30, annexure A1, along with the others, by Forest Department, my lord, seeking that our cases have been unduly, my lord, in 2012, we were sought to be brought under the, what is called Daily Wage Welfare Act 2012, 13 was the date of order. Then, my lord, we approached the tribunal, we are wrongly being considered under Umadevi. Instead, we are to be considered under 6890, my lord. That is the order passed on 28th March 2016, page number 30, annexure A1, my lord. Those the tribunal rightly, my lord, at that stage, my lord, said that the case of page number 36, para 6,
Yes.
it is not in dispute as per the official memorandum dated 8/5/2015. Applicants are engaged on daily wages with effect from 29/83, 16/84, 10/1/83 respectively. It is not known whether the applicants were discontinued in between. As per the OM, all the applicants are going to be retiring on attaining the age of superannuation respectively. As per the OM, the applicants were granted financial benefit under the Welfare Act. This was the cause of action for coming to the tribunal, saying that we are being wrongly classified under Daily Wage Welfare Act, whereas our rights have already vested and crystallized under 6890, because persons similarly situated, thousands of them have already been regularized. That is the occasion which made us to approach the tribunal. Tribunal then said, my lord, I will read further. The applicant demands that the applicants demands that they are not submitted the representation seeking regularization under the GO dated 6890. The relief of the applicant of this case cannot be considered. This stage, it is for the applicants to submit their service particulars and submit their demand to the respondent for redressal of their grievances. On submission made by the learned counsel for the applicant, the tribunal directs the applicants to submit their redressal of their grievances to the respondent for regularization of their service under 6890. If such representations are submitted by the applicant, respondent authority is directed to consider the representation to be submitted by the applicant as per 6890 within a period of 3 months. Therefore, this is the case stage when we approach the tribunal, and tribunal has directed, and the one kindly note, this order of the tribunal has become final. If this order direction given is anything wrong, the state could have challenged this order. It has not been challenged. It had. Therefore, my lord, the state accepted this order, and we made representation. A2, my lord, A2, A3, A4 are the representation made by us, saying that we are all persons appointed before 1784, and we have completed 10 years, and we long back, and our claim comes under 6890, and therefore consider our claim for regularization. Annexure A2 is the one representation. A3 is another representation by the present petitioner. Though there were 3 applicants before the tribunal, only one person is before this. A3 is the representation. A4 is my representation, who is the petitioner. Kindly see page number 42. The tribunal in the subsequent case says that he has not made representation. Kindly see. I have been appointed as daily wage employees. English, it is in English. I have been appointed as daily wage employees prior to 1984 and have so far put in 30 years of service. However, my services I have been treated as a daily wage employee without regularizing my services and granting only certain benefits under 8/5/2015. I am entitled to regulation with effect from 1190 and not for the benefits under 8/5/2015, that is Welfare Act. In this regard, I approached the KAT in application. In said application has been allowed by holding that I am entitled for regularization in terms of Government Order 6890 with reference to subsequent OM regarding certain benefits other than regulation. I have been asked to submit one more representation in this regard. Therefore, I am submitting this representation along with a copy of the order of the tribunal requesting that since I am eligible for regulation as I have been appointed prior to 1784 and rendered more than 2,400 days in 10 years, therefore I am a regular person. So this is my representation. Now,
Yes.
it is not that the state did not understand the representation or that you have not made representation belatedly, therefore it is rejected. That is not the case. The endorsement annexure
Yes,
A5, my lord,
We
A5,
understand.
A6 about
We
the series of
understand. Just a moment. Yes, what do you say?
Lord, I believe the relief granted to some of the persons who were not illegally appointed, but irregularly appointed is being misunderstood. What the court says is, in respect of those regularization which have already happened, it will not be reopened. Whether illegal or irregular, it doesn't matter. But insofar as the new, if my learned friend is saying in his case, it was already set in motion under 6/8/1990 order. Even if it has been set in motion, the decision of the Honorable Supreme Court in Umadevi's case in para 14 is that on the ground of, in fact, dealing with Dharwad Public's Works PWD case itself. Para 14, it deals with the very case and says that on parity, it cannot be granted.
Yes.
And the endorsement given in these cases to these persons are at annexure A5 to A7, my lord.
Yes.
And clearly it is stated that they were not appointed against, my lord, in the first instance, even to consider whether they fulfill the 4 conditions, they have to first establish that they were appointed in accordance with the constitutional scheme for public employment, which requires that they should be appointed through open competition on the basis of merit and reservation. Those conditions are not fulfilled. So the subsidiary conditions, whether they were appointed against sanctioned post, continued for 10 years without the support of court orders, whether they possess the qualification, these questions don't arise. Although in the endorsement, this is the answer given, my lord. The endorsement is at annexure A5.
Yes.
Page 44, my lord.
Yes.
But it's in Kannada. May I just read it out, after noticing Umadevi's para 53 and 54, it is stated, ಆದರೆ ನಿಮ್ಮ ನೇಮಕಾತಿಯು ದಿನಗೂಲಿ page 46, my lord. ಆದರೆ ನಿಮ್ಮ ನೇಮಕಾತಿಯು ದಿನಗೂಲಿ ಆಧಾರದ ಮೇಲೆ ದಿನಾಂಕ 1/1/1984 ಪೂರ್ವದಲ್ಲಿ ನೇಮಕಗೊಂಡಿದ್ದು, ತಮ್ಮ ನೇಮಕಾತಿಯು page 46, annexure A5.
Ultimately, it says that Umadevi conditions are not satisfied. I am not on that point.
Just a moment.
Yes.
Page 46, no.
Yes.
After the extract of Umadevi's paragraph 53 and 54.
Yes.
ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯವು ಮೇಲೆ ತಿಳಿಸಿದ ಉಮಾದೇವಿ ಪ್ರಕರಣದ ತೀರ್ಪಿನಲ್ಲಿ ಕ್ರಮಬದ್ಧವಾಗಿಲ್ಲದಂತಹ ನೇಮಕಾತಿಯನ್ನು ಸಕ್ರಮಗೊಳಿಸಲು ಸದರಿ ದಿನಗೂಲಿ ನೌಕರರು, ತಾತ್ಕಾಲಿಕ ನೌಕರರು ಮೂಲತಃ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಯಲ್ಲಿ ನೇಮಕಗೊಂಡವರಾಗಿರಬೇಕು. ಹಾಗೆ ನೇಮಕಗೊಂಡಾಗ ನೇಮಕಾತಿ ನಿಯಮದಲ್ಲಿ ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರಬೇಕು. ಸದರಿ ನೌಕರರು ಅಂತಹ ಹುದ್ದೆಯಲ್ಲಿ 10 ವರ್ಷಕ್ಕೂ ಮೇಲ್ಪಟ್ಟು ನಿರಂತರವಾಗಿ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸಿರಬೇಕು ಮತ್ತು ಅಂತಹ 10 ವರ್ಷ ನಿರಂತರ ಸೇವೆಯು ಯಾವುದೇ ನ್ಯಾಯಾಲಯ ಅಥವಾ ನ್ಯಾಯಮಂಡಳಿಯ ಆದೇಶ ಮಧ್ಯಪ್ರವೇಶದಿಂದಾಗಿರಬಾರದು ಎಂದು ಅಂತಹ ಷರತ್ತನ್ನು ಪೂರೈಸಿರುವಂತಹ ನೇಮಕಾತಿಯನ್ನು ಕಾನೂನಿನನ್ವಯ ಸಂವಿಧಾನಾತ್ಮಕ ವ್ಯವಸ್ಥೆಯನುಗುಣವಾಗಿ ನೇಮಕಾತಿ ಮಾಡುವಂತೆ ನಿರ್ದೇಶಿಸಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಿದೆ. Basically, they have enumerated the conditions in para 54. Next,
they have continued pursuant to the court order.
In this case, not appointed against sanctioned post, it is noticed in the next paragraph.
Pursuant to the court order.
Sir, and also based on the orders passed
Yes.
by the courts, they have been.
We'll consider
just
annexure K.
Para 14 may also be
My lord, I have got submissions to make, my lord. Kindly see, because there is a lot of misleading from the other side, my lord. Because I have to show
Counsel,
2
we have
judgment
heard you.
and Supreme
We've
Court
heard you.
judgment.
Anything further you want to say, please place it as argument notes and produce whatever you want to. We'll
Well,
consider.
written arguments I will file, my lord.
Yes, please do. We'll consider. Yes, please place the written arguments. When will you do that?
A week's time, my lord, week's time.
Just after. Give a date. Yes. No oral arguments, only written.
Yes,
submissions.
because your lordship said no oral argument, then that's why I am submitting written. I have no objection. Whether written or oral, that will be considered by your lordship. I have full confidence. Therefore, that makes no difference.
Yes. please.
Obviously.
With your lordship's kind permission. Lordship may kindly see, based on the Dharwad daily wages case, wherein the Honorable Supreme Court has laid down certain principles that are certain.
We understand, Counsel. We understand the argument. That was argued extensively last date of posting also, when this matter was not listed. If there's anything further, please. give us-
Accordingly, appointments were made,
Yes, we understand.
qualifying.
Yes, the
maybe-
only question is,
Here and there are certain.
please, if
That's-
there is anything further, you please place written arguments on it. Because we've heard these contentions extensively on the last date of posting.
But one thing is the state has, in the previous matters, my lord, in none of the previous cases which have been allowed, the state has pointed out that the case, Harvard case was overruled. Unfortunately, we have suffered orders without notice. That is a fact, my lord.
No, that is,
But
again,
it becomes a
yes.
perennial curium because of.
Yes, let
I
us-
think respectful submission.
yes.
Please.
13. Manjula D.
13, my lord. Manjula D is not in the panel of local, my lord. My name may kindly be shown. K. Prasanna Shetty. And my lord,
Last time also it was asked to be.
please, not this case is different. I'm sorry, my lord.
Second set not filed.
Fine, I'll file, my lord. Sorry, my lord. We came to know recently.
When do you want it?
My lord, weeks
Next
time may
week.
kindly.
Learned council seeks a week's time to rectify the office objections, show the name of the
Please.
learned council appearing for loci. List
Please.
after.
14. Government advocate.
For the respondent in this matter, my
My lord,
lord,
yes.
make my submission, my lord, for 2 minutes. My lord,
Eh.
the stay is granted in this matter, my lord. This is the matter of seniority. These two respondents have appointed in the year of 2010 itself, my lord. In the Mysore circle, they have been transferred to
Are
Hassan.
you ready to argue the matter?
Yes, my lord.
My
My
lord,
lord, the
date may
thing
be
is
fixed,
that,
my
my
lord. In
lord,
this, AAG is addressing his arguments, my lord. Can you
lord,
fix a
before,
date, my
in
lord?
two occasions, they
Tuesday,
have
my lord.
made the same submissions, my lord.
Wednesday?
Yes, my lord.
Lord,
Yes, my lord.
Yes.
Wednesday, we are.
Learned AGs.
finally, my lord, on that day, my lord, so they have.
To address arguments, list on Wednesday.
Lord, humble request, my lord, more than 2 times they have taken the same submissions. So I'm requesting, my lord, so stay is operating, my lord, so that is what. In my absence and without producing the rejoinder copy of the, before file the KAT, my lord, they have not produced complete documents before taking
Hear it on
stay.
Wednesday council.
That is not, my lord, it may have it on as finally, my lord.
15. N.K. Ramesh.
Hearing for respondent number 4. What's an application for vacating stay, actually, what has happened, my lord, in that the private, I was the applicant before the tribunal, my lord. The petitioner in 15.1, as the private respondent, whose appointment based on the final selection list set aside. As soon as the order was passed, I filed a caveat before this court. I appeared on caveat, the first date of hearing, opposed the interim stay being granted, and the court did not grant any stay and held that any order is subject to the writ petition. Thereafter, my lord, suppressing the existence of the first writ petition, the KA has filed second writ petition, which is 8125 of 2024, and obtained the same.
In the earlier matter, my lord, we have not been notified yet, my lord. Have to seek, my lord.
This is a case, my lord, wherein I have got 26th rank, my lords.
8125 of 24, the later writ petition is filed by the.
Okay,
Who's
Karnataka
opposing the
examiner.
first writ petition, my lord.
Are they served with the notice of the first petition?
Please, my lords, they were served, the matter was heard in January itself. Within 20 days, I checked online, I checked in the branch. They have been served a copy, and we had filed a contempt in the KAT. They were a party there, they filed wakalat there. They were very well aware of the existence of the first writ petition, my lord. And they did not make any submissions. They gave a stay, my lord. And
There was a caveat even against KEA.
the issue, my lord, was that the caveat.
No, in this,
was
no,
expired,
no, there was
but
no
yet
KA.
The office did not list the expired caveat as well. Every day I was checking
You had filed even caveat against KEA.
against all the parties against whom I had. My lord, what has happened in this case, my lord?
Notified.
It's a very simple case, my lord. I applied for the post of assistant professor in physics subject, my lord. While filling the application, my lords, what has happened is, my lord, if I may, I'm ready to argue the matter.
Just pass it over in here. Let us go through the list and come back to you. We'll pass it over.
Please, please.
Sixteen. Satish K.
Pertaining to transfer.
You have filed to vacate the interim order. We'll hear it today.
Yes,
Pass over.
yes.
Is this a matter which you are saying that it has been, today let us hope will be the lucky day for you? Yes. Pass over. Or
Admission.
unlucky. Or unlucky, we don't know. Anyway, pass over.
Admission
If my
17.
lord permits, my lord, I am ready, my lord, I'll argue.
16. Yes, not now. Let us go through the list and come back. Yes. Items.
Respondent number 1 and serial number 17.
Yes.
Serial number 17, appellant has collected NOC from me. He wants a re-sign, wants to change the council.
Hope's Technovative. Sureka
Eureka,
Hope's.
Eureka versus Eureka House.
Next
Yes.
week we need. Change ಮಾಡ್ತಾರೆ. ನೀವು ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Order of my lord, September.
You. You're appearing.
After I get an NOC, my lord, I shall file my wakalat number. The date may be given.
An order of September
File it in the
2023.
registry.
Please file it.
File it in the
Not
registry.
filing the wakalat number, my lord, I am filing a memo. Once I get a NOC wakalat, I shall.
Please file it.
The date may be
Yes.
fixed, my lord.
When?
My lord, it's a September order of 23, they're challenging and saying there is urgency. Injunction is passed by the trial court, which is confirmed by the commercial court, my lord. And there is willful disobedience of the order, 4 contempts miscellaneous applications.
But there is no interim order here. There is
There's
interim
no
order granted.
order here.
As on today, there is no interim order. ma'am.
Yes, list.
May be taken up at
15, it may be fixed, my lord.
15-7.
much obliged.
15-7.
Yes.
Eighteen, Ajit PP.
Upping for the appellant.
JDA, stay against construction.
In this matter, Lordship called for the records. Records has already come. In fact, I requested your Lordship to consider for final disposal. And for
They
the-
received.
another connected matter. In my learned friend has to file an appeal, my lord, that there is some office objection regarding, there is a delay. There is a delay in filing an appeal. ಹಾಕಿದ್ದೇವೆ. ಹಾಕಿದ್ದೇವೆ.
There's another one.
A
Apart from
connected
these,
matter.
137 and 190.
Yes.
In
Yes.
190, there are office objections. Have
there
they
is-
been complied with? Complied.
Not compliant.
It appears it is not.
There are 4 objections
Four
still required to be complied.
That is true, madam.
1,
Certified
2,
copy
3
of order.
and 5.
Certificate copy can be dispensed with because in another, in our matter.
Kindly see in the appeal itself, I have filed the certified copy.
All right.
So they have not seen that has
Page
been.
of the appellant to be.
Huh?
Minor.
Only thing is condonation application he has to file.
I have filed that also filed. Only 23 days delay. I have filed.
Copy ಕೊಡಿ.
The
Huh?
A is not before us. The A is not here.
Application with the file.
Where? Is it fine? Please serve a copy.
Delay.
No, delay application, copy. In fact, 37, my lord, normally, in a regular appeal and other things, the condonation of delay is in usual course, of course, small.
23
In 37, this court, this honorable court has taken a serious view in respect of 37 appeals. You must be very careful because in 34 itself is limited. Therefore, in 37, while condoning the delay, court will look into in
All right.
detail. Anyway, that
Whether
20,
cross objection is maintainable.
yes, yes, yes.
So cross objection from the rate of admission, your appeal is not yet admitted.
That's correct. That was really large.
Looking at it.
ಕ್ರಾಸ್ ಅಪೀಲ ಹಾಕಿದ್ದಾರೆ ಅದಕ್ಕಾಗಿ ಅಷ್ಟೇ ಹೇಳಿದ್ದು.
We'll condone the delay
Yes,
and list this matter for admission.
please,
And on that day
please.
can be heard.
And my lord, interim order, Lordship has granted a limited interim order last time. And submission was made that we have already entered into a joint development agreement. That is not correct because we have taken certificate copy of the encumbrance certificate. There is no such document at
I
all.
have filed the encumbrance certificate along with certain documents.
As a matter of fact, we have said that further alienation will not be done.
I have produced.
We recorded that the joint development agreement, he says that there is a joint development agreement. That
Even my lord, the award, whatever the award passed by the learned arbitrator, he has made it very clear that the cancellation will come into effect only after the payment is made.
Correct.
That he has not made. Either he has deposited or he has made the payment. Therefore, he cannot alienate the property.
Against that, he has an appeal.
Correct, but there is no interim order here, not.
No, so kind, that is a
Okay,
specific.
therefore, my lord, the
specific-
question is, whether he can alienate the property is the question.
That implication we can consider. Anyway, it is subject to the result of the appeal. Alienation has taken place during the pendency of the proceeding.
That
Dispendence-
dispendence, anyway, it is applicable, but still, my lord, the third party's right is created because ultimately it is a joint development agreement. Plan we have applied and it is sanctioned.
He has
Our
claimed only
instant plan has been
counterclaim.
sanctioned.
Counterclaim he has claimed.
The same interim order will continue till next date. We'll give a short date.
Please.
Delay will be condoned.
Please.
In the meantime.
Please.
It is brought to the notice of this court that an application is filed to condone the delay of 23 days in filing the present appeal.
Synopsis.
After going through the ground search in the affidavit accompanying the application for condonation of delay, and also consider the fact that there is one more appeal filed by the respondent in second in line. And said the appeal is not yet admitted. The delay of 23 days in filing the appeal is condoned. List this matter for admission on
Short date.
date.
So there are 10 years, the small farmers.
Till then, the interim order granted earlier stands extinct.
15/7.
15, 14th or 16th, 15th, there is another.
14th happens to be
Fourth-
a Sunday.
16th. 16th,
Monday, civil matters are taken on.
Days only civil matters will be. taken.
16th, madam.
Service matters
16th.
will not be there, which is why we thought. it could be
16th
a-
or 17th, madam.
We are fixing.
17th is a holiday.
15th, we have another serious.
Then let it be on the next Monday,
Yes,
Monday.
next Monday, 22nd.
Please.
20, yes, please.
19, Ready?
22nd.
Kindly pass on, senior will come. Total 21 is held up.
Preliminary hearing, so number 20.
My lords, appearing for the petitioners, kindly pass out the matter. Senior is coming.
Seniority and promotions backlog. What about the other respondents? R3?
But
Who's R3? Private respondent?
private respondent, R3 and R4, both are.
Have they been served?
Notice it appears is already been issued. Also served.
This is ready. This, they have been served.
This one.
Pass it over. Pass over.
Macho, please.
21 urgent, 22, Nagendra Nayak.
Appearing for the petitioner.
Suspension.
Yes, ma'am.
Extension of suspension.
Yes, ma'am.
Trap.
Yes, ma'am.
Voice recording.
Yes, ma'am.
Yes, ma'am.
Yes, ready.
Pass over.
Please.
Pass over.
Passed over, Matt.
I'm ready, ma'am.
Yes.
Number 15. NK Ramesh.
Not for the respondent.
Yes.
Yes, my lord. My lord, may kindly see, my lord, what, this is a case, my lord, where I applied for the post of assistant professor in physics subject, my lord.
Hmm.
I am a candidate with multiple disabilities, my lord. I have produced.
Yes.
I'll proceed, my lord.
Please, your file to this. Connected.
8125, 8125.
81.
And both the writ petitions, the grounds are the same, the facts are the same, man. Documents. My lords, may kindly see page number 49 of the writ petition, ma'am. 8125 of 20.
Assistant Professor Physics.
Yes, madam.
Is it in government colleges or university? Government colleges.
Yes.
Hmm.
Some. My lords, may kindly see annexure A1.
Yes.
Is the physical disability certificate having multiple disabilities issued by the competent authority, my lord?
Hmm.
I apologize, the writ petition copy. Yes, my lord, page number 49, annexure A1. Is a certificate, disability certificate, which shows that I have multiple disabilities,
Yes.
to a total of 63%, my lords.
Hmm.
Thereafter, after the notification was released, the application format, if I may show, my lords, is at page number 175. Page number 175, my lords.
Yes.
If my lords will see that serial number 13A, if physically disabled, there are only 4 options.
Yes.
Blindness and low vision, deaf and hard of hearing, locomotor disability, including cerebral palsy, etc. And 4th one is autism, intellectual disability, specific learning disability, and mental illnesses.
What is your disability?
I have locomotor disability, my lord, and low vision, my lords. What has happened in this case is there is no if my lord see there's only 4 options. There is no separate option for multiple disabilities, my lords. Because and if my lords will see my statement of objections, which I vacating stay application which I have filed. Page number, vacating stay application.
Just a moment, just a moment. This is the 95 Act, the new act. When was the notification?
My lord, it's dated 26th of
2021.
26th of August 2021. My lords, may kindly see my statement. Vacating stay application, my lords. I have actually produced the relevant roster. My lords, page number 4 for vacating stay.
Yes.
My lords, may kindly see para 15. In that, it's very clear that point number 4, which is autism, intellectual disabilities, specific learning, is clubbed with multiple disabilities. And if you see, my lords, application does not have any separate option for multiple disabilities. It is the one and the same. So I selected multiple disabilities, which is not specifically mentioned in the application form. So the only option I could select was autism.
You did select that?
I did select that, my lords. In fact, my lords, I did select that. I will show, my lords, may kindly see my application.
President?
My lords,
145 is the application.
my 145.
You don't appear to have selected anything.
My lords?
Please show us that you had selected.
I had selected, actually, my lords, if my lord sees the shape of the boxes in the application form, it is square.
Page.
My lords, my application is at page number 145.
Drop down, it is not square, it is drop down.
No, it is not. Page number 145 of the
A5.
145.
Annexure A5.
Yes, please, my lord. May I kindly see serial number 18A.
In 8125.
8125, my lord.
In 8125, my lord, is page 145.
Just a moment. If physically disabled, motor disability including cerebral palsy.
18 capital A.
18 capital A.
18
yes.
capital A, my lords, that first option of locomotor disability ends at muscular dystrophy. It ends at muscular dystrophy. Autism, intellectual disability, specific learning is another option, which I have very clearly shown, my lords, in the application, blank application, which I showed as the annexure. My lords, which clearly shows that when I fill the application.
Blank application is annexure?
Annexure, page 175, annexure D. 175, annexure B.
So therefore, if you click 2 and 3, both will come in the
Yes, that is
filled
what is
application.
Yes,
That is
my
what
lord.
has happened.
Yes, my lords. And my lords, what happened is
Please.
before the tribunal,
This is the only issue with the
only
application.
issue,
the only issue.
only
the
issue involved. In fact,
The
my
only
lords, what happened is the respondent number 3, who was the private respondent before the tribunal, did not file his application form what he has filled. The KEA took the contention that I have not ticked multiple disabilities. That is the only contention. They tried to mislead the tribunal saying that I have not selected. The candidate did not produce.
This is the one, huh? What is this? Format. No, application is online. Then how is this relevant?
Yes. Some of the options have been known.
Application form. He just wanted to show that this was the form which was given to him. He has picked physically disabled. But if physically disabled, he has to stick which? He says he ticks both because why? Yeah, that does not appear to be.
But that is a drop down. This is a format of the application which he has produced.
145 is his application.
Yes, that is the application. That's a drop down application.
Correct. So he has, according to him, he has ticked both locomotor disability, including cerebral palsy, leprosy cure, dwarfism, acid attack victims and muscular dystrophy,
There is,
and autism, intellectual disability, special learning disability, and mental illness.
no, there is no option, he has ticked for multiple disability. Multiple disability, there is specific,
Where have you given?
that is in the drop down. That he has not ticked. If he has ticked that, it would have come. That is that is the only, this online application.
According to you, is not the actual, there is a drop-down box for multiple disability.
There is a specific,
Where do you say so before the tribunal?
unfortunately, we have not filed statement before the government has taken over our role. That
Page
is
145
Yes,
discloses all disability which is having.
145
Does it not disclose all the disability?
no. Your Lordship, kindly take the government orders. There are 4 types of disabilities.
And the fourth type includes multiple disabilities as
Yes,
well.
yes. 4th is multiple disability.
That is the 2015 Act
Yes.
provides for 4, even the reservation is to be given.
Blind
in
and
accordance-
the locomotor, 1%.
Low vision, blind and low
Yes,
vision.
yes.
Then locomotor.
Locomotor.
Then
Then the multiple disabilities, where it is put together
first one is autism and mental illness. et cetera,
Mental
et cetera,
illness.
And multiple
Put
disabilities.
together 1%, that is.
Correct. Therefore, you've given 4 check boxes. He's checked 2.
He checked, no, he has not checked, he checked only 1. Multiple disability, there is a specific plot, this thing.
How
It
can
is
that be, counsel?
He himself has said,
Please take us to the Act. Please take us to the Act.
so that is there, that produced.
Your drop
yes.
boxes cannot be at variance with the Act. It has to be in accordance with what is stated
Yes.
there.
Well, the Lordship,
Can
can you
say-
take page 173 and 174, government notification itself is there, as per the act itself.
Please show us the Act.
Yeah.
33.
That is, .34 is the reservation.
Motor disability. And multiple disability. And immense presence. And the clause is 8 to be. Yes, there is the 5th. The categorization is fine.
There is 5th, my lords, but my lords, may kindly see page number 174. The notification that they have produced. Even in that, the option of, even in the, my lords, the application form does not mention a 5th option. Only 4 options
Or
are there.
does it not? That is the question.
It
Is
does-
it not? Are we not able to verify that?
My lords, I will verify through documents itself, my lords. Admittedly, the respondent number 3 has, according to them, selected the correct option. They have placed him in general merit, multiple disabilities. My lords may kindly see his application.
Just a moment, just a
Which is the
moment.
second,
What does, page 174 says?
this one option, my lords.
Hmm.
It's one option.
Autism with multiple
Yes,
disabilities.
it's one option.
Not one option. It is one reservation.
Please,
One
please,
reservation.
One reservation.
in this
One person
case-
is to be,
please.
have they given the option of multiple disability or not is the only question. They have
That,
not,
my lords, I can.
according to you.
Please, my lords, can we see page number 247 of the second writ petition?
Hmm.
Second writ petition, page number. The application filed by the private respondent who's
Hmm.
respondent number 3.
Hmm. Who
My
has
lords, may
been
kindly-
granted the benefit instead of you?
Yes, my lords, see the option that
247.
247, my lords.
Hmm.
Annexure C. This application, they did not file before the tribunal, my lords.
Hmm.
They took the contention, there was a separate option of multiple disabilities.
Correct.
My lords, may kindly see 18A in this case, my lords.
That is also autism. Is also autism, council.
Please,
Oh, that is also autism. 47. It's not
multiple disabilities
disability.
from amongst under clause A to D, including deafness, blindness and post and autism, intellectual disability. Those two have not only 1%. This is a separate class by itself.
What is the disability suffered by the
I got,
the petitioner in 28967?
In fact, they have not
It is,
produced a disability
in that
certificate.
note,
also.
It is partial.
We don't even know if he has-
disability, limb and hearing disability.
Therefore, it is multiple disability, not autism. It is multiple disability, not autism. You have also not,
Multiple disability, my lord, with more particularly to locomotive disability.
They have not even produced the
hearing
not
disability.
autism. Where is your
Not produced
disability?
your application.
not produced it before the court.
Please, my lord.
Where is your disability certificate?
Certificate. Because I don't have the,
Unfortunately,
the-
my lord, the petitioner hearing was not given an opportunity to file an objection before the case.
Where, counsel, is your disability certificate? We are asking you, please.
My lords, in fact, the respondent number 4 has got 26th rank, my lords. And the private respondent, my lord, number 3 has got 342nd rank, a difference of 78 marks, my lord.
No, then the only question would be, is
Further,
there an
my-
option for multiple disability? If there is not, then that clinches the issue.
And the KAT, my lords, order also refers to this aspect of the Disabilities Act.
Even now, you don't produce it, even before this court. Even before this court, you don't produce it. Why? You say you were not given an opportunity there.
Enough
You have-
opportunities are given.
Here, why is it not being produced? Total
What is the
disability
certificate?
is 7. Physically disabled, visually, hearing disabled, 15% permanent physical impairment. This is multiple disability. It's not any one disability. This is also, yes, higher person. Not that in the percentage may not be relevant because 40% if you have, you are entitled. But the question is,
Again, my lord,
if
I may.
was there or was there not a drop box for multiple disability? If it is not there, then the 4th drop box has to be accepted.
In fact, by laws, a drop back.
You can verify and tell us.
yes, ma'am.
Was it available? We'll go by what you say. Was it available?
Lord,
or
what had
was it-
happened, he claimed, Lord, it was a technical glitch, software glitch. Lordship, may kindly take page 29 of the judgment of the honorable tribunal. That is running page 29. In page 7, in page 11. That is para 13
Your 8,
by
the
8125.
page number is.
8125.
Yes.
28, para 13 starts from page 28. I'll read.
Hmm.
The applicant strongly contends that he ticked the box for both locomotor disability and multiple disability, but only the selection of locomotor disability is recorded and not the selection of multiple disability. It is not the case of the respondent state and the land council for respondent that the applicant was entitled to make only one selection among the choice
Mm.
of disabilities.
Mm.
And the strong contention of the applicant that he has selected both the options for locomotor disability and multiple disability has not been disputed. Hence, it lends credence to the contention of the applicant that the learned counsel for the applicant that the software glitch in not recording the celebrant, the two cannot be recorded. It's a drop down. One should,
Has been recorded, counsel, two has been recorded. In his case, what has been recorded is locomotor and autism
yes, no,
has been recorded.
yes.
Multiple disability has not been recorded. True. His contention is that there was no checkbox for multiple disability. Show us there was.
But that, no, that.
It's up to you now to show us that there
That-
was a
From the,
checkbox. From the third respondents also, it does not appear that she checked.
but I'll get
multiple disability.
I'll get the entire.
Only question is
It is
this.
from the, it is an online application. I have to get it
Exactly.
from the
Only question is this, was there a Dropbox for the
multiple disability or not?
Because both of them have not checked it.
Yes, if they have checked ballot, then, if petitioner has
Even if it is available.
Yes.
Then why did the other person who has not checked it, now you find her, him
No.
to be.
well, whether he comes or she comes, ballot, we have,
Exactly.
Yes.
Therefore,
we have no.
tell us what is the
Yes.
logic for disqualifying a person who was higher in the merit list.
Hey, Lordship, I have this on Monday. I'll get ballot from the,
He is higher in the merit list. He has
yes,
more
yes.
amount of disability. 40%.
Yeah, of course, his certificate is there.
Is the
His
benchmark.
certificate is there. Even before ballot, he filed the application. That also I saw, man.
My lords, I will.
I saw that.
In fact, drop-down box which learned counsel is referring to is
The application
itself in the application. My lords, page number 175 may be seen.
Mm.
Page number 175.
Mm.
There is one drop-down there. Drop-down is when you select an arrow and like downward arrow, then option should reflect. Here there are only three types, my lords. If the application is seen, there is only three shapes. One is square shape. One is round shape. Round shape is single option, my lords. If you see the
Correct.
questions, round shape is single option.
Correct.
For a
The
no, yes,
square shape is the drop down.
square shape is a drop down, but no,
Drop
no.
down according to you had only 4.
My lords, no, my lords, that is wrong. My lords, may kindly see page number 175.
Hmm.
Page number 175 may kindly be seen.
Format, this is the format of.
Mm.
It is
I
the
will
format
get
which
it
has been,
from the
my
computer.
lords may kindly see religion.
If it is there, I will
Religion is
straight
a
away
drop-down.
concede.
Just
There is no-
let him make a submission.
Religion-
Let us understand.
Yes, yes, yes.
Religion is an example of a drop-down box.
Drop down box. Yes, there
Yes.
is a,
District is also.
Select religion.
yes, yes,
District.
In this case, if my lords will see, are you claiming a reservation, for example? You can
yes,
select any number.
correct.
You can select rural, Kannada medium, which has been done, which has actually been done by the respondent number 3. He has selected rural, he has selected Kannada medium, he has selected physical disability. So this is an example of multiple ticking, my lords. So
So
this is not,
therefore, even in 13A, your
Please.
contention is that there
It is
can, in these 4, you
Yeah.
can tick any
Yes,
any number.
yes, my lords. It is not a drop-down question where you click on autism and multiple disabilities will come. It's not like that.
You tick 3 and 4 here.
I
You-
see, I
you
tick
tick
3 and 4, please, my lord.
Therefore, it is to be construed as a multiple disability, according to you. It has to be.
It has to be
That
considered, my lord.
is his contention.
Question.
I'll get from the computer itself, my lord, whether it's drop down or otherwise.
In fact, now what has happened, my lords, I have been placed, instead of selecting me under multiple disability, I don't know what has happened. The software has been, I don't know if the software has been manipulated or anything, my lords. I do not know, my lords. They have from multiple disabilities, they have put me in locomotor disabilities.
And locomotor disability would be.
There is
one
no seat for
specific-
that. There is no seat for that. So they have, though I have selected the same option as respondent number 3, I have been placed in locomotor disability instead of placing me in multiple disabilities.
I'll get the applications and my lord the drop downs, if it is there. Otherwise, I'll straight away I'll consider, there is no.
Further, my lord, I may be permitted in connected matter, my lord. Page 45, my lord, if disability is not as per the pro forma, my lord, the pro forma is at page 344. The signature of 3 doctors with medical.
Whether a
certificate has to be.
All that we'll
considered, my
consider.
Whether a candidate can question
all that
any
we'll consider.
multiple disability certificate when the examination
Because-
authority has.
The inclusion in that list is not under challenge.
Yes.
There was an inclusion of him as a physically disabled person, and that is not under challenge here. We'll consider.
I know it's Monday, my lord.
Monday.
Monday, please.
Tuesday.
Tuesday,
Tuesday.
Tuesday, lord.
Please.
Learned counsel appearing for the KEA. seeks time to get specific instructions as to the number of disabilities which were mentioned in the application format.
Yes.
This on Tuesday.
Well, the second matter, my lord, I'll take notice.
Yes, also
So-
takes notice. This together on Tuesday. Yes.
16, Satish K.
Yes. Good day for you. Is it?
Matter of status quo, my lord, they have been beating up, my lord, they can't stop because there is a status quo order since February, my lord.
Lord,
Yes, yes,
Lord, matter pertaining to transfer,
yes.
Lord, the applicant is in the cadre of Lord Deputy Controller belonging to Lord State Accounts Department. The respondent number 3 is Lord in the cadre of Joint Controller belongs to the very same department. Lord, by order dated 26/7/20
Just a moment, joint controller is the lower post
above,
above.
a cadre above.
Yes,
Lord, Joint Controller, Deputy Controller, Assistant Controller in hierarchy, my Lord.
yes,
By order dated 26/7/2021, but petitioner was posted as Chief Accounts Officer Ballari on my own pay scale. Since, my Lord, the post of Chief Accounts Officer is earmarked for Joint Controller.
yes,
The order of transfer itself says that, my Lord, I have been posted there on my own pay scale, which may have a bearing on, my Lord.
yes,
Lord, the petitioner took charge at Bellary
yes.
as Chief Accounts Officer, Jilla Panchayat Bellary on 21/9/2021.
21/9.
21/9/2020.
Order was on 26/7.
26/7.
Anyway,
Lord, I was not relieved in the earlier place. I took charge on 21/9/2021. Worked for about 2 years there. Lord, thereafter, by order dated 26/7/2023, petitioner was transferred as General Manager Finance, Karnataka State Medical Supplies Corporation Limited, KSMSC.
yes,
Lord, I have taken charge. I was relieved on 1/8/2023 at Bellary. Took charge in KSMSC on 3/8/2023. Since 3/8/2023, my Lord, I am working in Bangalore, my Lord, as General Manager Finance.
yes,
While, my Lord, my case is, my Lord, my posting to the present place is, my Lord, by way of transfer. It does not say that, my Lord, on my own pay scale I have been posted. The earlier posting order at Bellary says, my Lord, on my own pay.
Is there an order of promotion? No.
No,
There's no order.
no.
You've been transferred and posted?
Posted as a General Manager Finance, Karnataka State Medical Supply Corporation. Lord, 16/8/2023, while I was working in the corporation, my lord, I was placed on additional charge on my own, the order says, on my own pay scale. On 16/8/2023, as Chief Financial Advisor, Department of Rural Development and Panchayat Raj. Order itself indicates that, my lord, on my own pay scale.
Yes,
I am holding, my lord, both the charges.
yes,
One General Manager Finance in the corporation and my lord, Chief Financial Advisor RDPR. And R3, my lord, respond number 3 was posted on 14/8/2023 as Chief Financial Advisor RDPR, where I was holding an additional charge. But she is regularly posted there. On 14/8/2023. Not on
your charge is relieved.
16/8/2023, my lord, I handed over the charge to her.
Yes,
I am holding only, my lord, regular charge of, my lord, General Manager Corporation.
yes,
But impugned order is 1/2/2024.
yes,
It says that, my lord, under the impugned order, respondent number 3, who was posted about, my lord, 3 months ago, disturbs me. As, my lord, General Manager Finance order says, my lord, that, my lord, director post. Subsequently, my lord, it is rectified. My lord, the impugned order is at page 105. It says that, my lord, the respondent number 3 is posted to my place, and, my lord, I am posted to head office at Bangalore.
yes,
Lord, the impugned order says that your posting to as General Manager KSMC is on your own pay scale. Therefore, you go back to Lord, head office. But my transfer order does not indicate dated, my lord, 26/7/2023 is a regular transfer. My earlier transfer order to Bellary was on my own pay scale.
can you be posted to a higher post by way of transfer?
Please, my lord.
Can you be posted to a higher post?
Please.
By way of transfer? The
May not.
post is GM Finance. You yourself say that it is to be manned by a joint director.
But that is, my lord, Bellary, my lord.
No, this post of GM Finance in KSMSC.
He is not, my lord, he is not earmarked for joint control. I'll produce, I'll show, my lord. I'll demonstrate.
Yes.
It is not earmarked for, Lord, my contention is it is not earmarked for joint controller. By way of an executive order, you cannot earmark for joint controller is my case.
Therefore, it is a post that can be held by deputy controller.
Deputy controller is my contention.
Yes, that is
Lord,
the question which requires consent.
yes, please. Lord,
So that is the end of it.
please.
That is so, that is the end of it because you've been transferred regularly to the.
I am regularly transferred. Lord, if it was post meant for joint controller, all along they have shown as, my lord, on my own pay scale.
Will that make a difference? If the post, question is the post earmarked for deputy controller?
That is the only clarification. Right now, I'll clarify to avoid the timings, my lord. That is the only.
1 minute,
point.
1 minute. Lord,
There is a government order.
There is a government order.
Yes, that is, I produced. Thereafter, no, he misled the tribunal, got in a status
Lord,
order.
let him
Thereafter,
not,
I
Lord,
yes, no, I will take
let
it back.
him
Not
not
misled. I
say-
think he did not have the
I-
knowledge that, my
Some
lord.
charitable goods.
I produced the government order.
Yes, therefore,
like,
that is
if
the
he
question
wants
which-
to, my lord, argue
the
the,
question we are deciding. Yes,
Lord, my case is, my lord, the post, my lord, cadre strength of joint controller in the Department of State Accounts is 108. My lord, the head of the department, that is controller of State Accounts Department, has sent a proposal to my lord, enhance the cadre strength from 108 to 150. In the proposal, my lord, the post of KSMC is earmarked for my lord, joint controller. May I request my lords to kindly take, my lord, annexure A11. My lord, I have produced the translated copy. And, at the first instance, my lord, may I, page 107. I'll translate it, my lord. The translation is also produced. Page 107, not 108 is shown in the third column, which says that, my lord, cadre strength. 43 posts are, my lord,
Great.
is proposed, totally 150. My lord, on the left side, my lord, bottom, annexure 1 is, my lord, 108. Annexure 2 is, my lord, newly created post at page 107 itself, my lord, on the left side. Annexure 2,
What is this one?
one is, my lord, my lord, abolished. My lord, one in annexure 2,
It's only if that one is reduced that the figures will be right.
150. Yes, my lord, annexure 2 is, my lord, pertaining to newly created post, which is at page 114. In that, my lord, the post of general manager finance in the corporation is added. It is the proposal sent by the controller, which is,
When is this?
my lord, dated 27/6/2022.
Yes.
27/6/2022.
Has it been accepted?
My lord, it is not accepted. My lord, page 114. Page 116, my lord, serial number 33 is the proposal. The one of the post is the general manager finance. Not the proposal sent by the controller is required to be accepted by, my lord, Department of Finance. Department of Finance. Lord, the post in which, my lord, general manager finance in, my lord, medical supply corporation comes is, my lord, health and family welfare department. In the health and family welfare department, without, my lord, the page 143. I have produced the translation also, my lord. By order dated 11/1/2023, Department of Health and Family Welfare Services has earmarked the post of joint controller. Not page 147, which is in English. General Manager Finance is, my lord, shown as joint director. That is, my lord, joint controller. Page 147, my lord, serial number 5.
JD card.
JD cadre, joint director, which is equivalent to, my lord, joint controller, which is health department has earmarked the post.
Yes, 11/1/23.
Please, order is dated 11/1/2023. Lord, I approached the Honorable Tribunal, my lord, challenging the order of posting of the third respondent on the ground that, my lord, it is premature. Within a short span of 10 months, I have been,
Yes.
but I have taken charge on 3/8/2023. Within a short span of, my lord, 5 months, I have been disturbed.
Yes, the respondent had specifically placed this R1 on record.
Yes, my lord.
How was it
Respondent,
dealt with?
please, my lord.
Was it dealt with?
Yes,
by the tribunal?
my lord, the order of the tribunal is, my lord, page 33. My lord, reasoning starts from para 10, which is at page 44. tribunal says that the executive order,
Mm.
may I read, my lord?
Mm.
From the records and pleadings, it is clear that the applicant belongs to State Accounts Department. And while he was working as Chief Accounts Officer, City Corporation, Bellary, the first respondent has passed an order on 26/7/2023, posting the applicant to the present place as General Manager Finance, Karnataka State Medical Supplies Corporation Limited, Bangalore, to a vacant post, and has taken charge of the post of General Manager Finance, so and so, on 3/8/2023. The third respondent was posted as Finance Officer, Accounts Department, Karnataka Panchayat Raj Commissionerate, Bangalore, by order dated 14/8/2023, and she has reported to duty in the said place. However, the first respondent has passed the impugned order on 1/2/2024. Thereby, third respondent has been transferred and posted to the place of the applicant, and in turn, the applicant is transferred as Senior Deputy Director, Administration, Head Office, Bangalore, to a vacant post. It is the contention of the applicant that second respondent has sent a proposal for including some of the posts to the existing 108 posts of joint controller, and in the said proposal, Annexure 2 provides details of the posts which are proposed to be filled up by officials holding the post of joint controller and the post of General Manager Finance, Karnataka State Medical Supplies Corporation Limited, Bangalore, is provided at serial number 33. Learned Counsel urged that till date proposal is not acted upon and no proceedings were initiated. Hence, the post of General Manager Finance, Karnataka State Medical Supplies Corporation Limited, Bangalore, is meant to be officer belonging to Deputy Controller cadre.
Mm.
On perusal of the government order dated 11/1/2023, Annexure R1 produced by the Learned Counsel for the respond number 3, it is seen that post of General Manager Finance is required to be filled up from the cadre of Joint Controller, and the government by order dated 11/1/2023 sanctioned the said post of General Manager from the Department of State Accounts. Since the applicant is deputed from the cadre of Deputy Controller, as per government order dated 11/1/2023, applicant is not eligible to hold the post of General Manager Finance, Karnataka State Medical Supplies Corporation Limited, Bangalore. The reference made by the applicant with regard to proposal dated 26/7/2022, it is only a letter forwarded by second respondent that they wanted to sanction certain posts and proposed to be filled up by officials holding the post of joint controller. That being the situation, upon posting a regular holder of post, applicant is required to give way to the regular holder of the post. Therefore, posting of the third respondent to the place of the applicant is in conformity with the provisions. It is necessary to refer the circular dated so and so 12/9/2023 has restricted the to post any lower cadre government employee to higher rank post. Therefore, posting of the third respondent who is in the cadre of joint controller to the place of the applicant as Director Finance, Karnataka State Medical Supply Corporation Limited, Bangalore, is in conformity with the provisions. In view of consideration, Lord, application is dismissed. Lord, my contention is that, Lord, when, Lord, the head of the department is the controller, if the post itself is already earmarked, where is the question of sending the proposal on 27/6/2022? If post is meant for my lord, joint controller, which is my lord, issued by the Health and Family Welfare Department, Lord, the Finance Department, my lord, all of us belong to Department of Finance. Myself and respond number 3 belong to my lord, Department of Finance. But the controller, Department of Finance, my lord,
Post is in the.
in the Health and Family. Yes, ma'am. Post is in the Health and Family Welfare Department, but post is required to be earmarked by the my lord, Finance Department.
Yes.
And my lord, may I request that, my lord, I have filed a memo indicating the cadre strength of, my lord, in the recruitment rules, which is at Lord, memo 4/6/2024. Please, I have not at page 9, my lord, may I request my, kindly come to my lord, page 9. Lord, it
Yes.
is filed on
Page 9.
page 9.
Hmm.
This is the recruitment rules.
Yes.
Lord, page 10, serial number 3.
Hmm.
Your lordship will find the cadre strength
Hmm.
as
104.
106, 104
04 plus
deputation, and Lord, 2 is
permanent.
106.
Hmm.
Only to show that, Lord, once our service condition is regulated by recruitment rules by way of an executive order, can Health and Family Welfare Department, my lord, issue an executive order earmarking the post in favor of particular cadre?
Hmm. Yes.
My lord, in this regard, my lord, hmm? Hmm? Hmm. Lord, arising out of, my lord, very same department, finance department, but this honorable court has held that post cannot be not upgraded or downgraded or earmarked unless recruitment rules are amended. That is, my lord, MV Dikshit versus State of Karnataka.
Difficulty would be this.
Please.
It is not the post of deputy controller which is being upgraded. It is a post in the Health and Family Welfare Department. Is it required to change your cadre strength for the post to be upgraded in the Health and Family Welfare Department?
But
If it is the upgraded post, then the only fact that your transfer order does not say that it is
Is-
on your own basis.
yes,
By itself, will it make a difference?
but,
The post is one to be held by the joint
but
director.
it is not the executive order dated 11/1/2023 is issued by the Health and Family Welfare. Not the,
Exactly. Is it not the proper department to upgrade?
may not be, my lord, is, my lord, that is what, my lord, this honorable court has considered. My lord, in the PWD department, certain posts were upgraded. That is, my lord, lending department is, my lord, the state accounts, that is finance department. My lord, certain posts were upgraded
There,
in the Department of Public Works.
in the borrowing department.
Yes,
Hmm.
my lord, para 13
Hmm.
is the question framed.
Hmm.
Whether the order dated para 13,
When is it
Yes.
relying?
whether the order dated 15/12/2001 downgrading certain posts of account superintendent and directing that those downgraded posts to be filled up by promotion from the first division assistant or first division storekeeper in the public works department, irrigation violates provisions of section 3 of Karnataka Civil Services Act 1978 and therefore invalid. Lord, in the state of Karnataka, my lord, the recruitment rules are framed under section 3 and 8 of, my lord, Civil Services Act 1978. Lord, all the my lord, posts will be, Lord, included in the recruitment rules. My lord, once the recruitment posts are included, can it be, my lord, changed by way of an executive order? Is, my lord, answered at para 17. Para 20. Para 17 is the preliminary discussion. At para 20,
Is it your contention that in the state audit and account service rules?
yes, ma'am.
In this 66 posts, 66, 8 and 7, whatever, the number of posts
Yes, ma'am.
which are provided for deputy controller,
Yes,
the
ma'am.
cadre strength provided for deputy controller. This post is also included.
Is included.
That is your contention.
And my lord, otherwise, my lord, why the controller will send the proposal to upgrade it as to that of joint controller?
So it is your contention that it was a post included for your cadre for which a proposal has been sent for
Sent.
upgradation.
For upgradation,
Upgradation has not happened. in
which
the-
is not happened.
We understand.
Yes.
We understand the contention. Can we hear the respondent? We'll
Only
look into
to
this.
answer that.
Yes, which is the paragraph you want us to look into? The answer to.
But para. Just 20,
Yes,
22 and my lord.
20,
20,
22.
22
Hmm.
and not 24. Answer is at not page 27, para 27.
After coming into force of the Civil Services Act, creation, abolition of posts, specifying different category of posts in different branches of public service, specifying total number of posts, nature of posts in each category, and pay admissible can only be by way of rules made in
Rules.
the manner prescribed in section 3(2) of the said act and not by an executive.
Executive order.
Yes.
Then, my lord, the answer is at para, lord, 24. Similar issue in, my lord, Public Works Department.
Yes,
Last 3 lines, my lord, in para 2. When the state government issues a notification sanctioning the establishment of any particular cadre or creating, abolishing any post or determining the strength of each cadre and character of the post therein, such a notification issued in exercise of executive power under Article 162 will have to be considered as rules made by the government under any law for the time in force. In fact, it is of some interest to note that whenever the state establishes service cadres for any department, the notification is issued in 2 parts, normally on the same day. All the cadre and recruitment rules made by the state government prior to coming into force of so and so consisted 2 parts. The first part of notification containing executive order under Article 162 relating to establishment of state service, specifying the strength of the cadre, number, character of the posts and scales of pay. Second part of the notification containing rules made in exercise of power under proviso to 309 of the Constitution, regulating the method of recruitment and prescribing minimum qualification. Both parts are together referred to as cadre and recruitment rules. Ultimately, my lord, para 27. Therefore, it has to be held that notification dated so and so, downgrading certain posts of account superintendent to a lower scale are invalid, being contrary to section 3 and 3(3) of this so and so,
yes,
which was in the Department of Public Works.
yes. Yes, what do you say?
Yes, please. I will clarify the undoubted facts is, my lord, I am the joint control, he is the deputy control, both are from the State Accounts Department.
Correct.
The post required to be filled up from the cadre of the joint director as per the notification issued by the government, my lord. Kindly see the ink page 147, which my learned friend read out. General Manager Finance from the cadre of joint director
Yes,
from the Department of SAD, State Accounts Department.
yes. Will that do? Does it have to be rules notified?
It is, it has to be, so far as 108 post or 153 post, this is regarding, my lord, Finance Department, that is a proposal sent during 2022.
Hmm.
This order is passed subsequently, my lord, that's 1/11/23.
Hmm.
As per the government order dated, my lord, 11/1/23.
11/1/23.
Yes, 11/1/23, the post is required to be filled up from the cadre of joint director from the Department of State Accounts. Therefore, my lord, he is the first person holding that post, my lord, throughout since almost 1 year he is holding that post. It is not that, my lord, he is not aware of this government order. It is not that, my lord, he is on his own pay scale. He is not drawing the pay scale of a joint director. He is drawing the pay scale of a deputy director only. Suppressing all these facts, my lord, only referring the 22 letter written by the SAD, my lord, he is relying on the ground that, my lord, deputy control also can be posted. That is not so, my lord. The post required to be filled up from the cadre of joint director only as per the government order. Then, my lord, government order R6, my lord, tribunal held that, my lord, in I produced the R6, my lord, it was referred by the tribunal, my lord. In any department, lower cadre officer shall not be posted to higher post on his own pay scale, and there shall be a prohibition of such posting. It is also well noted by the tribunal.
What do you say about this judgment?
When he just referred, my lord, I don't think so it is relevant to us, my lord, because, my lord, the particular post is in question is, my lord, reserved for, it has to be filled up from the cadre of joint director only. I don't know.
Karnataka Civil Services Act 1970.
Then, my lord, since 5-2, my lord, I have been reported to duty on 5-2, my lord. Any of the assumption of chargement status quo order is passed. Any of the status quo order here also, my lord, I am not there, not here, my lord.
You are there. You have a
That for
full-time
this
post.
period, for regularization of
Don't
this
worry
period,
about
my lord,
that.
I am submitting, my lord.
You are absolutely there. You
Yes,
are the chief
that- that-
financial
yes,
advisor.
yes, that has to be-
RDPR.
Yes, because, my
Don't
lord,
worry about that. Neither here, you don't get a pie extra.
no, not required.
You
This
get your-
period has to be regularized. That's what my condition.
No,
Since
I-
he is a holding.
Only in answer to your contention that you're neither here nor there. You are very much there. Yes.
My lord, para number
Attack.
5, my lord, of the judgment, which says the post of which the applicant is posted to be occupied as a joint director. Since the applicant is in the cadre of deputy director,
Correct.
he is not having a capacity to hold the post, my lord.
That is the
As such,
question.
we have posed an eligible candidate to that post.
What do you say about this judgment?
My lord, when he is referring to the judgment, he is not providing copies to us, my lord. On all the cases, my lord.
In all the cases.
In all the cases, my lord. He won't give the copies to us
That is
when he is relying on the judgments.
a whole scale damnation.
Yes, my lord.
I'm sorry,
My lord,
if
in
that
all
is-
the cases, my lord, whenever he refers, he
Please.
won't supply copies to us.
Please serve a copy.
Lord,
I don't know, my lord.
Lord, if we say, Lord,
Never mind. Yes, please serve a copy.
Lord,
Here the
yesterday, my lord, about an year ago, I have served a copy. He says that, my lord, it is not served.
No, my lord.
Without serving a
No,
copy,
my
my lord, it will
I
not
I am
come.
submitted copy,
Let-
it's
let-
not available on file. I
council,
told.
let us not join issues on the question whether copy has been served. Serve a copy, we'll hear you after lunch.
Yes.
Yes.
Here this, I don't know about that judgment, but here, my lord, the post is reserved for joint director and he is a deputy director.
But
That's,
that is enough is the question.
no, it's a government order.
So it was the same in the other case also. Please look into that
On
judgment.
12/9/2023, government order is there, my lord. It was clarified. Deputation is not permissible if a person holds a post.
Please look into this
Yes, my lord.
judgment and
Yes,
please,
my lord.
please
Waiting for
tell
it.
us after that. Yes,
Yes, my lord.
we'll continue after lunch. Yes, 25. You inform the other side. The Union of India. Please inform the other side.
Lords, serial number 30. Serial number 36, my lords. Kindly have it next week, my lords. Senior has some inconvenience in the
Have you
evening.
informed the other side? It's only
Lords,
state of Karnataka.
State.
36.
That's Date.
20 is passed over matter. Have you informed? That again is only the,
Serial number 36, date may be. Dateful.
Next week.
ರಿಟರ್ನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ನಂಗೆ ಅದು ಜಡ್ಜ್ ಚೇಂಜ್ ಆಗಿದ್ದಾರೆ ಮತ್ತೆ again ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಹೌದಾ ಬರ್ತಿದ್ದಾನ ಮತ್ತೆ
ಇನ್ನೊಂದು ಮಾಡ್ತಾರೆ ಈ ಸುಮ್ಮನೆ ಇನ್ನೇನು
ಬಾಲು ಬಂದಿದ್ವಿ ಮೇಡಮ್ ನಾನು ಇಲ್ಲೇ ಇದ್ದೆ ಬರೋಣ ಅನ್ಕೊಂಡೆ ನಿಮ್ ಜೊತೆ
ಹೊಸ ಚೇರ
ಇಲ್ಲ ಕವರ್ ಹಾಕಿದ್ದೆ ಅಷ್ಟೇ ಹಳೆ ಚೇರಿಗೆ.
ನನ್ ಬ್ಯಾಗ್ನಲ್ಲೂ ಸ್ಪೂನ್ಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಎರಡು.
ನಾನೇ ಹೇಳಿದ್ದು ಏನೇನ್ ಬಾಕಿ ಇದೆ ಸ್ಪೂನ್ಸ್ ಎಲ್ಲ ಮೇಡಮ್ ಬ್ಯಾಗ್ ಒಳಗೆ ಹಾಕ್ಬಿಡು ಅಲ್ಲಿ. ಹೊಸ ಮನೆ ಅಲ್ವಾ ಬೇಕಾಗುತ್ತೆ ಅಂತ. ಹಾ
ಹೇಳ್ಬಿಡಿ ಫೋನ್ ಮಾಡದೆ ಬನ್ನಿ ಆಯ್ತು ಗೊತ್ತಾಯ್ತು ಆಯ್ತು.
ಡಬ್ಬ ತಗೊಂಡು
ಹೋಗಿದ್ರಾ? ಹ್ಮ್.
ಅಷ್ಟೊಂದು ಇನ್ನೂ ಆಗಿರ್ಲಿಲ್ಲ. 12 ಮೇಲೆ ಸೆಕೆಂಡ್ ನಾವು ಕರೆಯೋದಲ್ವಾ, ಅದಕ್ಕೆ ಟೀ ಕುಡ್ಕೊಂಡು ಹೋಗೋಣ ಅಂತ ಬಂದೆ. ಈ ಹಬ್ಬ ಬಂದ್ಬಿಟ್ಟು ಅಲ್ಲ ಆರಾಮ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು. ಇದೆಲ್ಲ ನೋಡ್ದೆ ಇದು ಏನಪ್ಪ ಅದು ಪೇಪರ್
ಬಿಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ಇದಕ್ಕೆ ಬಿತ್ತು.
ಆಮೇಲೆ ಚೆನ್ನಾಗ್ ಗೊತ್ತಾ? ಓ ಸಕ್ಕತ್ತಾಗಿತ್ತು.
ಕೆಲಸನೇ 4 ಗಂಟೆಗೆ ಹೋದ್ರೆ ಅಲ್ಲೊಂದು 2 ಅವರ್ ರಬ್ಬರು.
ಯಾರು
ಗೊತ್ತಿಲ್ಲ
ಇದು ಪಾರ್ಕಿಂಗ್.
ಆಫ್
ಮಾಡಿರ್ತೀನಿ ಊಟ ಮಾಡೋರಿಗೆ. ಮೂವರಾಗ ಅನ್ಕೊಳ್ಳಿ ಆಫ್ ಮಾಡೋ ನಿಮ್ಗೆ ನನ್ನ ಮೇಲೆ ಜಾಸ್ತಿ
in view of the admitted factual position that the petitioner was a person born on the local Kada of the Hyderabad Karnataka region, and since it is contended by the official respondent that it was without noticing this fact that he was granted a posting outside the region, we are of the opinion that the finding of the tribunal that the order of transfer was withdrawn on valid grounds before it was given effect to cannot be faulted. If petition fails, same is accordingly dismissed.
41, Satish K.
Having considered the provisions of law, government orders, transfer guidelines, and the circulars placed on record, we are of the opinion that the initial posting of the petitioner outside Hyderabad Karnataka region would be one issued in administrative exigencies and in public interest. Therefore, we are of the opinion that the finding of the tribunal that the transfer order was a premature transfer without stating reasons cannot be found fault with. The fact that the third respondent had been granted a posting to Sedam in Kalburgi, or that the petitioner had assumed charge during the pendency of the proceeding, will also not make a difference to the situation. The petition is dismissed.
Okay.
We have referred to all the government orders in both the writ petitions, almost verbatim, because we wanted it, the public interest aspect under that clause 5B, that has also been highlighted. No, and we have also said that there is no challenge to the guidelines as well, especially in your case. We have said that there is such a contention, but without a challenge, we cannot consider that. It's complete. Yes, let's call that.
230 matter, admissions, number 42, Kiran Krishnaswamy.
Before both of you start, there is small doubt because of the amendment to the Karnataka High Court Act. Section 5 says. No, this section.
No, that is the Civil Codes Act.
For High Courts Act.
For the High Courts Act amendment.
Doesn't say either prospective or retrospective.
Says neither. Section 5. That is whether, that is on the amendment to the High Courts Act. Whether it is prospective or not is a question.
Commercial appeals.
That on a different, this is not a commercial appeal, that is a difficult. No, well, we are in a dilemma now.
It's an appeal, not section 37 application. Not saying anything contained in the law.
It is first appeal. Section 34 is not first appeal.
Correct.
It is classified as MFA for this reason.
There's no difficulty. The question would be, is it before the division bench of, that is the only problem. If it's a commercial appeal, it would, there'd be no difficulty. Then we would be the commercial appeal. Yes. Correct, correct. Correct, correct.
Division bench. Now this amendment is in respect of the procedural aspect. So.
Therefore, it has to be deemed to be retrospective. Not only that, it appears to be a substitution. Therefore, if it's a substitution, it has to be. That is our prima facie view on it. We are waiting for clarifications.
Demanded from Supreme Court, then the same, they said, we have to have some clarity. So
We are hoping that at least by Monday we'll have a clarity on this issue. Next week? Date, please. Fourth.
Fourth.
Fourth. We are almost at the end of the hearing. It's only for a, now, anyway, let us see. Third, of course. Then we know for sure whether we have to hear it or not. Then we'll give it.
3-7.
3-7. Why not? Of course. 2-7. Yes.
B group, see number 43, Unikrishnanya.
There has been malpractice. That authority has got after referring to indulgence payment, their lordship referred to one more important judgment in the case of railway. The All India Railway Revenue Board at page 390. Now, how they refer to this railway, All India Railway Revenue Board, and how they also refer to one other state of Tamil Nadu versus Telangana, and then how they distinguish it with indulgence in Kerala is very important. If I may read from the 49.
So which volume say? Yeah, okay, sir. Sachin.
Yes.
In one of these where the board had invited application for military forces of as many as 10.2 lakh applications for issue of which 5.85 applications are found. The eligible candidates required to appear at the test 3.52 lakh candidates appear after 2016 was selected in part of the state. Those who qualified were part of the education at that stage. It was noticed that certain malpractices had taken place during the examination. In the area involving mass copying, leakage of question paper and enforcement. Vigilance Department recommended the matter to refer to CBI. Recruitment board decided to conduct the retest. This decision was challenged by certain candidates who had taken the first examination. Tribunal rejected the plea while considering a challenge to the decision of the tribunal. High Court held that there was no reasonable basis to cancel the first selection and directed the board to finalize selection on the basis of the first attempt, save and except for 62 candidates in whom applications are. In appeal, this court noted the report of the Vigilance Department being litigated. Several candidates were suspected to obtain answers for the questions a few hours before the examination were given were accepted. In respect of 62 candidates, there were serious allegations of impersonation, and on those two, it was found that 6 candidates adopted unfair means to secure qualifying on the investigation primarily established the leakage of question paper to a sizable number of candidates. This seemed to be a pre-planned and the possibility of involvement of the staff of the board would not be moved out. In this background, this court considered whether the High Court was justified in interfering in the decision of the board to conduct a retest for those who are obtaining the minimum qualifying marks in the first seminar. During the pendency of the proceedings before this court, the board was directed to declare the result of the litigation. The retest of those candidates who are obtaining minimum qualifying marks in the first seminar. Three, to go ahead with the first seminar as requested by the High Court. Combining the investigation with specific candidates, they choose a period to be. The High Court held, the court held that the High Court had misguided itself in directing the board to accept the third option and had transgressed the limitations of judicial power of petition. The court emphasized that the first alternative would have been time consuming and expensive. If the board believed, and this is important, if the board believed that the best option was to conduct a request for a candidate who had obtained minimum qualifying marks in the first seminar, the decision of the board was fair and reasonable. The decision of the High Court, it was held, would only perpetuate an illegality since there were serious allegations leaking of the question papers, large scale impersonation of candidates, and mass copying in the first. According to the decision of the regulator, the judgment of the High Court was satisfied. A more recent decision of two judgment was in the state of Tamil Nadu versus Ivy. The teachers of the board in the state of Tamil Nadu invited application for selection of posts of lecturers in government qualitative college. Written examination of an objective type and candidates were required to fill a frame of. There were allegations of large-scale malpractice in the written examination involving tampering of white marks. After re-evaluation, the state was performed the exist particular 186 candidates who were beneficiaries of a fraudulent observation of marks. A decision was taken to cancel the examination which was conducted for selection to the post of lecturers, as the board was of the view that there were chances of more malpractice being unearthed at a later stage, and there was a serious doubt about the purity of the process. The division bench of the High Court held that the fabrication of records pertaining to 126 candidates and when segregation was possible, the entire examination ought not be cancelled. In appeal, this court adverted to the decision of Inderjit Singh Kenor as well as the view which was taken in Ohit Mishra versus State of Gujarat, wherein it was held purity of the examination process. Whether such examination process pertains to assessment of the academic outcome or suitability of candidate for employment under the state is an unquestionable requirement of the rationality of an examination process. Rationality is an indispensable aspect of public administration under our constitution. The authority of the state to take appropriate measures to maintain the purity of any examination process is unquestionable. It is true and said, a principle of law in the light of various earlier decisions of this court that where there are allegations of occurrence of large-scale malpractice in the course of conduct of the examination process, the state or its instrumentality are entitled to cancel the examination. The court has on numerous occasions approved the action of the state or its instrumentality to cancel examination whenever such action is believed to be necessary on the basis of some reasonable behavior to indicate that the examination process is initiated. They are also not obliged to seek proof of each and every fact which initiated the examination. It was further held in the judgment as follows: identifying all the candidates who are guilty of malpractice either by criminal prosecution or by an administrative inquiry is certainly a claim for this process. If it were to be the requirement of law that such identification of wrongdoers is a must, and only the identified wrongdoers be eliminated from the selection process, and until such identification is completed, the process cannot be carried on. It will not only result in a great inconvenience to the administration, but also result in the loss of time even to the innocent candidates. On the other hand, by virtue of the improved action, the innocent candidates, for that all the candidates, including the wrongdoer, still get an opportunity of participating in the best examination process to be conducted. Justice Nageshwar Rao held that the view of the division bench of the High Court was unquestionable and absurd. In the extreme case, the court initially conducted an inquiry on its own regarding the allegations pertaining to manipulation of OMR sheets. The court found that the few benefited the tampering of the OMR sheet on a deeper scrutiny. Sufficient evidence was found against 196% who were beneficiaries of fraud in the alteration of marks. The court was convinced that there were chances of more people being involved in the manipulation of marks, for which reason a decision was taken to cancel the entire examination. But what falls is the bona fide decision was taken with the board to instill confidence in the public regarding the integrity of the selection process, without having interfered by the High Court. sufficiency of materials on the basis of which a decision is taken by authority is not just within the body of the High Court in exercising its power of judiciary. More materials is being unearthed in the investigation, and several people have been arrested. The investigation is in progress. The court noted that the candidates who had a chance of being selected and appointed as lecturers in government college on the basis of the result of the academic commission may be inconvenient, but a serious doubt entertained by the board about the magnitude of manipulation of the examination has to be given due weightage. The judgment of the High Court was according to that. Decision rendered to the board, Govind and Kalaimani all would emphasize that, this is a very important proposition, that a recruiting authority is entitled to take a bona fide view based on the material before it, that the entire process stands initiated, as a result of which the stress selection process should be initiated. The integrity of the selection process cannot be lightly disregarded by the High Court, subject to take its own subjective opinion on the sufficiency of the material which has been taken into account by the decision-making authority. Undoubtedly, fairness to the candidates who participate in the process is an important consideration. There may be situations where candidates who have indulged in irregularities can be identified, and it is then possible for the authority to segregate the candidate from the identical candidate. On the other hand, there may be situations where the nature of the irregularity may be manifold, and the number of candidates involved is of such a magnitude that it is impossible to precisely delineate or segregate the candidate from the identical. A considered decision of the authority based on the material before it taken bona fide should not be likely to interfere with the exam judicial review unless it stands initiated on the grounds of unreasonableness and proportion. Therefore, their worships very clearly laid down several propositions of law. Number one being that the recruiting authority can take a bona fide view by appreciating the material. And if they take a decision, then the High Court should eventually believe that unless there is a prima facie or a very serious case of violation of the unreasonableness of the proportional. And then in paragraph 57 amongst there was the facts of this case. So in 57 there are bullet points 1, 2, 3, which is more or less like similar to my case. Paragraph 57 those 3 points. There was committee appointed, and the last line in the paragraph 57 says committee upon preliminary examination noted the gravamen of the complaints, which involved the allegation that as many as 50 candidates who had 5 marks in tier 1, secret less than 50 marks, and tier some candidates have 0. The absence of randomization enabled candidates who were closely related to sitting sequence. A significant portion of the candidates belonged to a concentrated geographical area. So there was leakage and other issues involved. And how their lordships dealt with brought about a couple of lines. Now, can we turn to para 62? We can skip through the other discussion. About a couple of lines at para 62. The first 4 lines and last 4 lines in para 62. Beginning with words on 23/2008, the deputy minister noted on the basis of the recommendation of the DSSP on the allegation on the alleged irregularities in the examination, that all candidates who are in the zone of investigation may be scrutinized and checked for impersonation before the decision of the board regarding declaration of the result. Then there are last 2 days. Noting that there should be zero tolerance towards corruption in officials who may join government through improper examination are just not acceptable. A decision was taken to cancel the entire examination. However, an age relaxation was provided to the candidate who appear in the new examination. Then there are in para 64. In para 64, about 6 of current time, just a couple of times there, beginning with verse on the contrary. On the contrary, the report of the committee found a deficiency of a systemic nature, which caused serious doubts on the legitimacy of the entire process of the recruitment involved. In my case, also, the committee has found systemic deficiencies of a systemic nature, and all of them cast a serious doubt. It may not be proving a serious doubt is sufficient. And how their lordship dealt with that can be found in para 65 and 66. And 67 not, which are the good correct. Para 65. You can skip the first 6 lines, but I will begin from the words in response. In response to this, I am referring to the submission made by the ASD. In response to this, the ASD pointed out that while assessing whether the recruitment process has been compromised, the factors or irregularities must be looked at cumulatively to ascertain whether they are sufficiently grave to cancel the recruitment. We find ourselves in agreement with the learned ASD. So long as there is sufficient basis to contend that the mass scale irregularity have occurred, this court need not indulge in a roving inquiry to rule out all possible explanation and alternative scenarios which where such irregularity would be justified. Therefore, the submission of the AG was that we can't look at individual, is there any strong evidence of paper leaking? She pointed out that look at the different pieces of evidence. Cumulatively, if you see, it will cast a doubt regarding the purity of the scientific information. Then what paraphrases is, recruitment of public services must command public confidence. Persons who are recruited are intended to fulfill public functions associated with the function of government, where the entire process is moved with flaw. Its cancellation may undoubtedly cause hardship to a few who may not specifically be found to be involved in wrongdoing, but that is not sufficient to nullify the ultimate decision to cancel an examination where the nature of wrongdoing cuts through the entire process so as to seriously impinge upon the legitimacy of the examination, which have been meant for the recruitment. Both the High Court and the Tribunal have, in our view, erred in laying exclusive focus on the report of the same committee, which was concerned with the issue of the report of the same committee to one facet of the matter. The DCM was justified in going beyond it and ultimately recommending that the entire process should be cancelled on the basis of findings which were arrived at the report of the customer. Those findings do not stand for arbitrary, nor has the tribunal found any fault with those findings. In view of the matter, both the defects of the tribunal and the report are answered. 67 is also important. During the course of the submission, ASD has placed on record that the fact that the subsequent recruitment process, a number of 282 candidates participated afresh, and age relaxation has been granted. In 2017, 133 of 281 candidates participated and 13 selected. In 2020, 87 out of 281 participated and 3 of them were shortlisted. During the course of the submission, ASD has also submitted that even among 281, it is not possible to conclude that all of them are maintained. In the view of which we have definitely not necessarily to dwell on this subject of the matter once the court has arrived at the conclusion that the entire process was initiated and the cancellation was then not the directions are issued by para 69. For the above reasons to be order and direct, the facts which have come to light in the course of the hearing of this matter presently reflect on the serious cost of the process which was conducted by DSSP. DSSP and CH-3 must now take adequate measure to ensure against the recurrence of such instances which erode the credibility of and public confidence in the recruitment process. We direct that the comprehensive exercise to revisit the modalities and safeguard be carried out with a period of 2 months to ensure that the probity of the recruitment process can be maintained. The notification will be so issued by our CH-3 cancelling the examination held for the purpose of recruitment post of the regular and the post is upheld. Appeals filed by so and are allowed. Similar circumstances, their lordships, after referring to the earlier judgment of Inderjit Singh Gehlot, have held that what is important is the sanctity of the selection process, because it is for public purpose. Even if there is a doubt, then the recruitment authority is justified and entitled in cancelling the entire selection process and conducting a request. So my submission is that in view of this 2020 judgment in the Sachin Kumar judgment and the distinguishment that we have seen, Inderjit Singh Gehlot does not hold the lead. So there is no requirement to conduct a segregation, a difficult process of an almost next to impossible process of segregation. And segregation as per Sachin Kumar judgment is where in the examination hall the irregularities have taken place. Where not it is possible, there may be some CCTV cameras, somebody would have seen the evidence and recorded. It is not a case of leakage. In my case, not there is strong material evidence available to indicate that the question paper has been leaked, file has been issued. So once it reaches 1%, now we are doing a digital case, it can spread across. So we are willing to conduct the retest as was done in this case, and we are willing to do the age relaxation to any number.
What was the contention with that?
About that particular point, that the written examination is the main examination to qualify for the interview. So he has qualified to the interview level by passing the written examination. So therefore, this submission that the marks of that cannot be considered is wrong. If he had not appeared in that particular examination, he would not have qualified for the interview stage now.
It was a qualifying exam.
Yes, yes. That was
And in respect of that post also, there was allegation of leakage?
yes, yes. Yes, there was. But the entire process, now what if we go by the proposition laid down in this case, We need not go into the nitty-gritty of things. If the process, we are concerned about the sanctity of the selection process. Because ultimately the public is watching it. There is a constitutional mechanism which is laid to recruit to these posts which are statutorily governed. It is not like any private employment. So there should be absolute sanctity. Once there is some tip of any tainted material there, then the entire thing is gone. So what this statement says is that I as the recruiting authority, I am of the bona fide opinion that my selection process is tainted. So therefore, I should be allowed to go into the retest without causing much injustice then by giving them easy life.
Yes. Yes.
Even if the judgment of yes, right, and I don't want to take a lot of in the paragraph.
Yes.
We make no literal food suffice to say that unless there is a large scale malpractice, and there the committee, your lordship will find the fact that in paragraph number 11, committees were formed, two committees, independent committees were formed, which came to the conclusion that the tainted and the untainted cannot be segregated. It was not a case of appointment, and that is how the other judgments distinguish the earlier decisions where examinations were cancelled. First, of course, was the Bihar School Education, where the distinguished said it was the cancellation of examination, not cancellation of appointment. But before I take a logic, there are just two judgments which I would want to say because those are subsequent to this, and that is a. But before I take a logic to that, and this royal logic attention to a few facts. That I had the benefit of while when learned AAC was reading the report, I could make a few notes, and I would just want to because I confirmed with my client, and therefore I would want to place it for your logic. The first is even as on today, admittedly, the tainted officers, the employees of bar, barring one or are still within bar. That's an admitted position. Now, insofar as the admit cards, there are two things that I want to point out. The first is the statement of Street Priya, which was read out, where they said admit cards were sent late. First thing is, there is no candidate who has come before the court or any authority who has come and said that admit cards were received late. Second, admit cards were never sent to anybody. There was a link which was sent on email which the candidates had to download. Then your lordship will ask me why did that Priya lady give such a statement. But your lordship may kindly have a look at question number 1 of that lady's statement. She is appointed in the year 2020 after we were appointed. She has got nothing to do with this recruitment. Her statements are in relation to an altogether different recruitment 2021 which the DAE rights cancelled. So today her letter is being projected before your lordship to say that look, this is the statement made by our own officer, there is collusion and therefore we have cancelled it. She is appointed after we are appointed. She has got nothing to do with issuance of admit cards, she has got nothing to do with the selection process, and her statement is today relied upon to say that my selection is tainted with impurity. Right. Second thing that I would want to point out is the statement in CH-3. Right. There are two things which I would want to point out in the statement. Before all of this, let's kindly examine this aspect also.
Yes.
The inquiry is by the people of bar.
Yes.
The witnesses who have given statements are the employees of bar. There is no material case, or at least no material was read out to say that we issued notices to these persons who have appeared before us in the committee and we have recorded their statements in this manner. The reason why I am saying this would assume significance is, please have a look at the statement of CH-3. These statements would show that the person CH-3 would sign on 20th of July 2022. The committee members' signatures is dated 25/7/2022. So admittedly, it was never made before the committee.
Yes.
And kindly have a look at para 39 and 26 of the statement of Chandra, where that person would admit, the other day also I pointed out that this person, Shripal, in whose email or pen drive examination question paper was wrong, he would admit at para 39 or 26 and say, yes, Bar had permitted this person to carry his personal laptop since there was no other computer available. Bar permitted him to carry his personal laptop and his personal laptop was being used by Bar. That is the statement made by their own witness. Today it is thought to be projected as saying that he had used his personal laptop, there is malpractice, so on and so forth. Admitted cases.
Not the use of the personal laptop at all. It is the sending of, even if he's using it, his laptop in the office premises. Why does he need to send it to his personal mail?
That is also answered, I think, in para 26. So it is also in para 26 where they would say that in order to get these question papers, since there was no facility to take this, he had to send it to his mail and it was printed in conference room number 3 or 4. At para 26 and 39 of A. Chandra's statement, it is available. No, I know.
Today, give full opportunity. My understanding could have covered all this then. Now, this is my reply. If my reply, there is no joint up, there is a clarification we can give. If he refers to fact statement to seal the cover which has been received now, let me first instruction. I mean, he just he had an opportunity tested, he could have been, I would have got the instructions from that made sufficient. He cannot go back to that. If he has any clarification on Sajid Kumar's judgment, which alone I have referred to in my reply, he should contact that. Why is he going to fact it?
I don't have the benefit of that seal cover inquiry report even as on date.
No, but I don't have this
materials. And the only reason how I got these materials, because it's in the seal cover, you'll ask me how do I know about this? These statements of A. Chandra, which they are relying upon, which I got to know the day before, are given along with the charge sheet to other employees. My candidates have gotten it.
Yes.
The reason I am pointing out these things, there is a submission that I would want to make it. But ultimately today, as I pointed out, the tainted officials are still within. Today, their admitted cases, yes, these persons are tainted, therefore we are removed. These officers are tainted, they are still within. And therefore, their intention is that everybody was in pollution. Then I ask, because today they are going against their own officers. Then I ask myself, the assumption today is question papers were in Srikanth, and therefore if there's a possibility it could have been. Then I ask myself this question. Why is it not the case that their officers have put up the story and the statements made by those witnesses? Everything is internal, including the forensic report. There's no independent agency that has come to its conclusion. Their officers, some of their relative may not have been selected in the selection. Somebody they would want to select in the next recruitment. Therefore, this could have been possibly a statement made by their own officers for their own gain. But that assumption is never made. But they would want to make the contrary assumption saying that there is this mass question paper leakage, mass copying, so on and so forth.
The only proof that is available before your lordships is the statements which are made behind our back and the statements to which we have no access to. And that is being sought to be projected before your lordships as proof to say that the process was tainted and there was large scale irregularity. But the reason why I would want to point out all these things is that ultimately today as proof what is available is what is in the sealed cover and nothing else. If there is an independent agency which would go into this issue and ultimately come to a conclusion that the malpractice or the large scale irregularity such that there cannot be any segregation, then it is a different reason. Today, what is being told to your lordships is this is the material available. This is sufficient, and therefore my conclusion is wrong. Sufficiency of material and the conclusion need not be one and the same. And that would lead me to just two judgments. I don't want to read all three. I'm just saying because these two judgments have consciously will make to it and that's why. The reason why I'm pointing out 2019 is this was not noticed in section. That is the reason I have placed only this judgment and not the other judgments. That is the second state of respect. Right. This was a case where the your lordship notified that it was a case of cancellation of the selection process and candidates who had appeared that their appointments to cancelled. And that is how this matter came up where the High Court as well as the tribunal had held in their favor. Therefore, para 12 and 13, where they would rely on Sandhya application, Union of India versus Court Sector, internal phase 11. Para 11, the findings are heavy.
Yes.
We have heard the learned counsel for the parties, including the counsel for the applicant. We deemed it appropriate to first turn to the executive order of the court dated on a fair basis of the favor of arbitration. This court wanted the limited grievance of the applicant that in the wake of defective questions and incorrect answers given, the High Court will have submitted the applicant to the after noting that the court granted liberty to the applicant to approach the High Court for by doing so, no liberty was granted. So on and so forth. This is another liberty. Then, para 12, the respondents have relied upon the dictum in Sandhya application that especially petition only against the judgment for the review of application. Be that as the judgment of the High Court in review application is so and so and will certainly not across the other. For the High Court has restated the dictum and specified that it would be open to the applicant to separate the tainted candidates from the untainted ones and to pass a fresh reasons order after providing opportunity to the affected candidate. The High Court has also clarified that the order passed by the Chief Executive Council has been brought on the sole ground that it was by the principles of national justice, having passed without giving notice and affording opportunity of hearing the candidates concerned. And also because the said order does not refer to the fact that the exercise was already undertaken by the appellant to distinguish the case of tainted and untainted candidate and arrive at a conclusion that it was not possible to do so before issuing the improved order dated so. So the appellants have now relied upon the opinions given by the expert IIT Allahabad and IIT Kanpur, as noted in the report submitted of this court dated so. The same was certainly not available to the appropriate authority before the order was passed on 11/8/2017. Indeed, the appropriate authority took into account two inquiry reports, but the same did not evince that an exercise had already been undertaken to distinguish the tainted and untainted candidates, or that it was not possible to do so as to uphold the decision that uphold the decision of declaring the entire selection process as void. Had the appropriate authority done that exercise and recorded its satisfaction in that behalf, to be reflected in the order of the chief engineer on zone. So the High Court would have followed the settled legal position expounded in Union of India versus Court Sector
that the nature and extent of illegalities and irregularities has to come to a conclusion about the future course of action to be adopted in the matter. Further, if the mischief state is so widespread and all pervasive, affecting the results or making it difficult to pick out the person who has been unlawfully benefited or wrongfully deprived of justice. Such a case, it will neither be possible nor necessary to issue future show cause notice. In that case, the only option would be to cancel the whole selection process and not limiting to one selection. This view has been initiated with the recent decision. The dictum in the two judgments relied upon by the appellants, both Chakradar and Vikas also will be of no avail to the appellant in the fact situation of the present case. Suffice it to observe that by reporting the assembly, the earlier decision on the court had neither different nor. Therefore, my submission to your lordship is not that the selection could not have been cancelled at all. My submission is, without undertaking the exercise to arrive at a conclusion that the tainted and the untainted can be segregated, to simply say that we have material and therefore we will cancel the entire selection, that position of law might not be correct.
Yes.
Now that your lordship asked me a pertinent question the other day as to why not the opportunity of notice to have been given. But my possible answer would be that the facts that I was pointing out, I could have possibly pointed out to the appointing authority and said, look, these statements are not pertaining to my selection. These are the defects in the inquiry report. These statements could not have been relied upon by you to issue show cause notice or to take any action. And I possibly could have had an opportunity to convince the appointing authority not to take any action. Today I am deprived of that benefit. But the second interment case number 13, of course it's an interim order, but that's an issue that is alive and burning around today. Case number 13. In the interim order, your lordship may ask me what is the necessity to point out an interim order because it does not bear on any law. But I'm only trying to point out to us that in a similar situation, in West Bengal teachers, that may just draw your lordship's attention that here was a case where CBI had investigated.
Yes.
Here is not the case. Today there is no independent agency. But internal page 18, page 30. There are. I'm not relying it as a precedent, but I'm saying that to say that BSS is the law of the land and that no other view is possible might not be the correct position. But page 29, the translations are noted. Page 20.
Yes.
Page 28. The allegations are made on para 24.
Yes.
At point number 2, I'm just drawing it to your lordship's attention because the allegations are much graver in this case. Yet the Supreme Court wants to do a certain extent, which I want. Page 29, para 25.2. In a selection process having large magnitude, cancellation of the entirety of the selected list should be a matter of last hope recourse. Whereas segregation of tainted candidates is possible, only such appointments should be directed to be discontinued. The above consideration must apply to a situation where the petitions were filed nearly 3 years after the appointment was made. The direction to set aside the entirety of the appointment would have serious repercussions to employees who have served the same. Where appointments which are tainted are capable of being identified, it was manifestly unjust for the High Court to set aside the entire process. At the bottom of the page 28, para 27 would take note of 65B certificates which are not available. From the material which have been placed on record before the High Court by the SSC and by the CBI during the course of it, a further issue which should merit closer analysis as to whether appointments which suffer from taint can be specifically segregated. If such an exercise is possible, it would be unfair to set aside the entirety of the selection, which extends to approximately 25,000 court cannot be unmindful of the impact of setting aside a large component of who have been recruited for class 9, 10 and class 11 and to be the consequence of the income judgment was paid aside. Assuming that segregation is possible, this court would have to determine the modality which would be followed for that. Now today, that entire exercise is unavailable.
That exercise in the context of this case may not be so easy. Hypothetical example, let us say X is the recipient of the leaked question paper, he is not a candidate. He is going to distribute it to XYZ candidate. During the course of investigation, again, because of some quid pro quo situation, he may say only Y and Z have received the question paper, X has not received, though he has dispatched it. These are things possible, so.
That is the reason why I'm making this repeated submission. Why not an independent fair investigation? Why should not, I'm not asking a lot of to answer this, but I'm asking myself. Why should only bar conduct an inquiry without notice to anybody else? And the notice is not even to the persons who have given statements. And
Yes.
a forensic report that is supposed to be quite legitimate report is conducted by bar employees for their own purpose. And I have nothing to say on it. Today, all that I'm served with is other than the order of termination, nothing else.
No, what might be the reason for the bar to do this?
That's what they want to know. What might be, there are many. One or two instances might be, the employees who are taking it, their relatives might not have gotten selected. They would want to have this cancelled. They would want to offload the shame on their bullets to the candidates. And they're still within the department. I asked myself, could it not be a possibility that this is the handiwork of those officers if it is to be assumed that question papers are leaked and that I have received it? It could also possibly be assumed that it is their handiwork. But therefore, to enter into the realm of assumption without even an iota of material to say that these question papers were in fact given by Shripa to the candidates. Assumptions could vary on either side, and therefore, and professional jealousy is not unknown. The relatives of so many candidates were relatives of so many officers. The officers the other officers did not want the positive and I am looking to this
Yes.
and the last judgment case for the this and this only sufficiency of material and application of mind.
Yes. Yes.
We may hasten to add that by publication of mind to the material available to the competent authority is an essential prerequisite for making a valid order. The requirement should not be confused with the sufficiency of that material to support any such order. That's all that I would want to point. According to them, it may be sufficient material.
Yes.
But that would not simply mean that the order passed by them is valid.
Yes.
Effectively narrowing those loss to the manageable number of candidates. Here, some 1,000 candidates to they have 40 candidates for get the examination. Interview is not clear to CH-3. Importantly, interview was the ultimate and exclusive determining of the final selection. This comprehensive evaluation rigorously assesses each candidate's capabilities and suitability for the role. My selection was based entirely on my performance in this interview, which remains uncontested in its fairness and integrity. Any alleged irregularities in the screening test did not influence the outcome of the interview. I demonstrated my theory and qualifications independently of the screening tests. During the interview process, given this canceling the selection process and termination my employment due to alleged screening test irregularities is disproportionate and unjust. My appointment was clarity to a fair and rigorous interview process. Therefore, this screening test merely functioned
Yes, we understand your contention. That is, Hmm.
Petitioners like that 18 posts of question papers are in possession of Shripa. For remaining 9 posts, he don't have the possession. And I have wondered whether it is 18 posts or 18 papers, because in this agreement, 43 question papers are there. And secondly, similar to me, there are 8 disciplines where there is no weightage for screening test marks. So Shripa may not attempt to take possession of those question papers. And one more thing I want to clarify that in the tender office, the tender option is not available for every person. It is only available for executive officers. So to transfer any matter from one PC to another PC, either you want to use land or internal mail. And they have conducted the forensic analysis of only Shripa computer. But how the question papers came to Shripa is unknown. Secondly, there is two-step authentication for opening the question paper. One is password for pen drive. Second is password for question paper. Shripa has password for only pen drive. He don't has a password for question paper. Unless even though he may steal the question paper, but without having password, he cannot open.
yes. Yes,
And one more thing, I request petitioner to submit the 65-week certificate for their forensic analysis. Not done by the independent.
yes.
But firstly, they're all prior to
Hmm.
and one is sufficient because that the professional agency, but if that means it is not in Kumar, the was comprising of director vigilance and disciplinary.
Yes.
So, there was no professional agency which was in. So therefore, there is no such opposition, but in every case, there should be a detailed explanation. And as regards the regulatory commission, your lordships must satisfy on the sufficiency. I would like to read in paragraph 56, the Chief Kumar. Then lordship said, the integrity of the selection process cannot be lightly disregarded by the court, substituting its own subjective opinion on the sufficiency of the material, which has been taken into account by the decision making authority. That is what he said. And while accepting the submissions made by AG Madhavan, the lordships also said, this court will not indulge in a rolling inquiry to rule out all possible explanations and alternate scenarios where such irregularity is. So therefore, the law is now very clearly laid down that so long as there is a cloud of doubt, in this case, the bank account can take email leaking. Even these two are sufficient for the last day. And what is important as far as the Chief Kumar is the sanctity of the person. The leakage of the sending of the email by from the official ID to the Gmail ID and the corresponding bank account which shows that itself is sufficient to meet the requirement of disturbing the sanctity of the person. And one final submission is, but as a recruiting authority, I am concerned about my selection process. So if I have pulled on I want to read the process. The termination is only a consequence, but it's an inevitable consequence. I'm not actually terminating them. I'm pulling down the entire selection process because of the delay. So it is an indirect and inevitable consequence. They have to bear it. And to mitigate that, we are going to give them one more opportunity.
They will give me, if I'm call, I can't go anywhere else. No, but if it was cancelled at the stage of test, I would have gone somewhere else, some other employment. Today I can only apply to the figure than call. That's those are things connected only a few years ago. Will be the age benefit.
Yes. Yes. Reserve. Yes. Yes.
Sixteen.
That will
On the last date of hearing, the petition was not recorded. And the 14% he went to the tribunal, he moved for contempt, he do over. So please not.
Of course, interim order will remain in force. That we did not anticipate at all.
Although your worship said, the order sheet does not capture. So and this man took advantage of that, he went there, he filed an application, I mean, he moved them. He said there is no interim order continuation. Someone then he does all this. And he pass an order.
Yes. Specifically that the interim order shall stand extend. Please record specifically that the interim order shall stand extend and upload it. Yes. Yes.
Yes, ma'am. To realize that judgment, my lord, here it's case is entirely different. Where, my lord, there's a rules, there are specific rules. By executive order that was passed, my lord, that's a question raised, it is entirely different. Here, my lord, that is not his case that there was a rule that post has to be filled up from the deputy director. There is no such rule. And alternatively, he has not challenged this government order at all. He's not questioned that the government order, my lord, where we says, my lord, that post has to be filled up by the joint director. Nor, my lord, he has produced any rule to state in that, my lord, that post has to be filled up from the deputy director cadre only. All the posts, he is, I think, my lord, seventh or eighth holding the post, all are joint director. I produced one such previous order. All are joint director, except this.
Where is that?
Annexure R7, my lord. Prior to his posting, annexure R7 typed 169, my lord. 169, my lord. Serial number 1, Srimati Manjula HP, joint director. That is actually 24/6/21, he typed as 23. Previous to his posting, 24/6/21. She was a joint director.
R7?
R7, my lord, in page 168 is in Kannada. 168
Eight is wrongly mentioned.
wrong mentioned in the typography. In the original date is 24/6/21. 24/6/21 is original copy is 168 R7. That is previous to his posting. In earlier posting, all are joint director. That is not his case that but posted from the deputy director. Then the judgment, my lord, the question, my lord, paragraph 13 in that judgment, just now he referred, on the contention raised, the following points are consideration. Whether the order dated so and so downgrading certain post of accounts superintendent and directing those downgrading. The question was downgrading and cancellation, my lord, there was a post prescribed under the rule. Then they said, my lord, by executing order, then that cannot be. Therefore, my lord, in that context, my lord, that judgment was, it is not relevant to this case at all. May I read?
Yes.
Therefore, my lord, health department has, it is not that with effect from 11/1/23, post was there, not with effect from 23, and earlier also was there, and along with the other post, my lord, this new notification, new government order was issued. Therefore, post has to be filled from the joint director, I am from the cadre of joint director, he is from the cadre of. Now interim order was granted on the ground that he is under the election duty. Election duty, my lord, it was over long back, my lord. It's within the jurisdiction only. His transport, posting is given to him. Therefore, my lord, the cadre, my lord, he can't hold that.
Where
cadre.
is he posted to?
In Bangalore only, head office. In Bangalore, here only.
Yes.
Para 5 of the judgment is my contention. It's very clear that the post of the applicant is to the post of occupied by the joint director, since the applicant is in the cadre of deputy director. He is not having a capacity to hold a post. He is wrongly placed, and it was rectified by an order of transfer. By not inserting on own pay scale, that may not create any right for him to hold a post. When an eligible person was available, we have posted him. It's not a case of premature. When he is not having a sanity to hold a post, he may not have created any right over the post. If eligible candidate is available, we have placed him. As per that, this repetition does not serve. This
Yes.
judgment does not on the transfer. It's on gradation of post and abolition of post. This may not be.
Yes.
Lord, only,
Yes.
only short reply is, my lord. The government order dated 11/1/2023, Lord, cannot be taken into consideration for the fact that, my lord, it is issued by Health and Family Welfare, and my lord, post is to be, my lord, deputed from the Department of Finance.
Where is the material to show us that the deputation to the post of GM Finance in the KSMSC is to be filled up by a deputy director? Where is the material to show us? It was a post to be filled up by a deputy director. In the judgment you relied on.
Yes.
Specifically, there was a provision in the rule that the post is to be held by the specific category of officers.
Yes.
Are we right? Therefore, in this case, what is there to show that here in this case that you relied on, MB Dikshit, the method of recruitment prescribed for the post is account superintendent by deputation of an officer in the cadre of account superintendent from the Department of State Accounts. That was the method of appointment. What is there to show that the post of GM Finance is to be filled up by a deputy director?
Lord, I have not produced any, Lord.
Therefore, the question of 11/1/23 order being against any rule does not arise because there is no such rule.
Lord, if that is so, my lord, if the post is meant for joint controller, Lord, in the Department of Finance, Lord, there was no occasion for the controller to earmark and, my lord, create a post in favor of joint controller. But this proposal is dated 27/6/2022. Lord, by the controller. Controller says that there are only 108 posts. Lord, the cadre strength of joint controller is 108. Kindly come to page 109. 109 is, my lord, annexure 1. Annexure 1 to the, my lord, proposal, which says that these are 108 posts earmarked in throughout the state. Within 108, Lord, General Manager Finance, Medical Supply Corporation is not included. An inference can be drawn, Lord, my submission is, my lord, kindly come to, my lord, page 109 for a moment. It indicates 108 posts. Totally, my lord, at page 113, 108 posts.
Seen that.
Then, my lord, annexure 2 says that these are the 43 posts which are required to be upgraded as, my lord, in different, throughout the state. That is 43 posts. Then, my lord, 108 plus 43 minus 1 post is required to be cancelled.
That is on 27/6/22.
22.
Yes.
Which is not accepted by, my lord, the finance department.
Yes.
But
reserved.
at any rate, my lord, the finance department is deputing the officers unless the post is upgraded in the finance department. Health and family welfare, my lord, my submission is, my lord, I have served a copy on, my lord, other side. But,
Yes.
I don't know, my lord, for the, what reason he has made a hue and cry.
Ideally speaking, judgment should be shared much earlier.
In
They are
advance.
sitting together since morning. He has not opened this mouth.
My learned friend is saying that, my lord. Yesterday, when Lokayukta matter was addressed by, arguments was addressed by him at length, my lord. He is referred all the judgments, my lord. Whether he supplied one copy to us, let him say, my lord. Let him say, my lord.
But
He is making allegations against me. Let
no,
him
no,
say that.
I
Please
am,
Yes.
don't indulge in this kind of
Yes, last may note.
arguments.
Yes.
in court.
Last may
Please,
note.
this is,
Last may note.
this is beneath you.
Yes. Last
Yes.
Last may made down the ink page 125 and 110 in the interim order. Because on that day, my lord, we assumed the charge that was recorded, my lord, to regularize. May I ask for
Yes.
vacating the interim order, my lord, now?
Yes.
he is the cavator, my lord.
Waiter, my lord, he is, I should not refer, my lord, he sold the copy previous day. He said, man, matter is coming some
Please
after.
counsel. Yes. Reserved. Let us decide
Yes, please.
matters on the merits of the
Yes, lord.
petition rather than
Please.
anything else.
Would not appear or caveat, my lord, because my name was wrongly shown. On that ground, my lord,
Yes.
he could have informed that he has not.
Office room ಮಾಡಿಲ್ಲ ಅಂತಂದು ಹೇಳ್ಬೇಡಿ ಮತ್ತೆ.
ಏನಿಲ್ಲ, ಕಾಪಿ ಶುರು ಮಾಡಿ.
ಇಲ್ಲ acknowledgement ಕೊಟ್ಟಿಲ್ಲ, office room ಮಾಡಿಲ್ಲ.
Only for the officer to seniority is order. Yes, reserved.
Please, please.
Eleven. M. Nagaraju.
My lord, I got the information. Maybe my learned friend may have not been properly informed by his client. Already he has been relieved on 24th only, I'm told. No, no, no. You said that he is going to be relieved now. That was the submission he made.
24/1,
24/6.
24/6.
Yes. So he is pressing for a stay, saying that he is going to be relieved now. It's coming up on 10th, my lord. I'll get instructions. I'll get
Please get
instructions.
instructions.
It may be
Yes.
decided on 10th.
Already having been relieved, counsel, we cannot hear you on the merits of the matter.
That's what I
Yes.
made submission for having, having what was 5 years for the strength of the interim order. Now they have been reviewed, I told him, Lord. So 2024, I will, the order of the honorable case is on that day. 24/1/2024 is the order of suspension. 2/2/2024, the order of honorable KAT has issued the interim order on the strength for the.
But it's very unfair to me if he says that he is being relieved today. And he is pressing for a stay. I did not, the matter is listed for the first time today. I did not have any information.
Nobody has taken charge now?
My lord,
Fourth person is also appointed
that
here.
information,
Seniority exam.
that information I don't have.
Only additional charge of that, nobody has been charged. My lien has been shifted from 250 Virajpet, 250 kilometers away from this.
In any case, on 10th, it will be taken up. I'll assist the court to dispose of the matter on that date.
The same case where the death certificate has been wrongly issued.
No, not him.
What is the charge?
Death certificate, annexure A one, it is certified, I am not issued.
All right, that is one charge. What are other two charges?
The other two charges, the issuance of the genealogical tree, that is not by myself, and one is work by annexure A two. Annexure charge is that the issuing Kata certificate, Fauci Kata certificate, that is by
What
the
certificate?
inspector,
What
not by
cer-
myself.
What certificate?
Fauci Kata,
All right,
Fauci Kata.
All right.
Interstate. Fourth one is that I have not issued it. I produced a copy to show that, that does not, they reply, they said that does not contain the seal of the officer. It is signed by the officer, signed that. All the four charges, nothing not free, that's free.
So let there be an interim order till next date. We'll give a short date.
That he has been relieved already on 24th, I'm told, my
Thing
lord.
is, from this order, what is seen is somebody from next neighboring taluk is ordered to take charge, that's all, right? Nobody is posted,
That information I don't have, my lord.
but that's what it says.
Already heard it, already heard it.
Last sentence says,
Last sentence.
or the learned counsel appearing for the petitioner and the learned counsel appearing for the respondent. The present petition is filed challenging the order passed by the Karnataka State Administrative Tribunal in proceeding number so and so. In terms of the impugned order, the petitioner's application is dismissed. Learned counsel for the petitioner would submit that the petitioner had the benefit of interim order. Interim order passed by this court, alva? Passed by this court.
Interim order,
No, Allala, Minde. Interim order was rejected earlier, then you came here.
No.
Passed by the tribunal till the disposal of the proceeding before the tribunal. Full stop. Learned government advocate would submit that the petitioner has been relieved, video order dated 24/6/2024. Stop. We have also considered the contentions relating to the alleged charges framed against the petitioner. Full stop. By considering the fact that the petitioner had the benefit of interim order in the pendency of the proceeding before the tribunal, and also consider the fact that no other person is posted to the post held by the petitioner before the dismissal of the application. The petitioner shall continue in the said post till next date. Please.
Chokka ready?
Yes.
Sorry?
May commence my argument, I engage in senior counsel in total 16 in matter.
Left to you.
It's up to you.
We are not insisting for senior counsel to appear. We are not dissuading you from arguing the case.
If you want the senior counsel to make the submissions. Up to you.
If you're
Not
not,
in our hands.
if you're not fully prepared, we are not insisting you to argue.
Senior will come, as senior told commence argument. Had in this dispute. Developer and the contractor. The appellant is the developer. He has entered into joint development agreements with the landlords and the GPA. Both documents registered from the landlords. The appellant. That the appellant intended to develop the property by way of the villas. By way of the villas. That is the agreement, the joint development agreement dated 19/2/2011 from the landlords. Along with the GPS.
There is one ex parte order operating against you,
That,
granted by the court.
yes, madam, that the respondent filed the suit for the injunction in the trial court. That is 13/9/2023 has filed. That this the arbitration, the petition filed on 14/9/20.
14/9.
One day after.
Oh, interim order passed on next day, 15/9.
Yes, sir. That is, I produced the last date of hearing, I filed memo.
So you are not aware.
I am not aware of the case, 1330/2023, the ex parte order was granted by the trial court. That next day on 14/9, we filed the arbitration petition before the commercial court. On 13/9, they have filed the OS original suit against me. That order was not communicated within the 1 day gap between the two petitions. One is the earlier, my respondent filed the injunction suit against not to interfere in the project. I filed the arbitration application section 9 before the commercial court for not to alienate the property and not to transaction in the company accounts. Restrain the respondent from alienating any villas and restrain the respondent from the receiving the and transaction of the amount in the company accounts. That is the interim applications filed before the the commercial courts. That the trial court-
You admit the fact that respondent has invested certain amount pursuant to the second agreement.
And both of the appellant and the respondent, after the DMSA agreement ended 25/1/2017, but the project of 60 villas, both of them have mortgaged the entire 60 villas and they have got the loan party close for development of the project. That is the mortgage deed. This is the appellant is the one of the co-applicant in the mortgage deed.
Understood. So this power of attorney is coupled with interest.
Coupled with the interest.
How can you cancel it?
And that is the first the disco. And the 2022, he has filed the criminal complaint against the appellant for 406 and 420. Even though the arbitration clause in the DMSA agreement, he has went to the police station, filed the complaints. Investigation was started and the bank accounts were freezed. But he has cancelled the power of attorney, he has cancelled the power of attorney, that addendum general power of attorney. Thereafter, he has issued the notice and filed the arbitration application for restrain them not to alienate the properties and not to transact.
That is understood. How it is permissible? The power of attorney is irrevocable because it is coupled with interest.
Yes, the power of attorney, we have cancelled, but again, they have filed the appeal and.
How can you cancel? That is the question. It is coupled with interest pursuant to the power of attorney has invested the amount.
General power of attorney, that DMSA agreement was not referred in the general power of attorney. That is the agreement 25/1/2017. And the general, the GPA was executed on 28/9/2017. The both documents were not referred in the general power of attorney. Earlier DMSA agreement 25/1/2017. And subsequently
Now
28.
construction is at what stage? Construction is what stage?
Construction won the project, the first phase project 77 villas was already completed. And they have got the partial occupancy certificate. And the second project has not commenced.
No, he can sell the property only if the second project is completed.
Even the second project and the first project, the villa.
Let me make some, the submissions made are not fully correct. But I have given the synopsis on the last occasion.
Just a second. When you intend to sell the property?
As and when it is completed, means.
How long will it take?
He has been creating objections, for every stage, he has been, just now he said that is an ex parte order. The High Court's order, it is not so. He had entered caveat, or we had given a copy to him. Then, the Honorable Court granted an interim order, so with liberty for him to move for vacation, which he has not done.
Just before that, are you admitting the fact that there is an arbitration clause which will bind you
No,
to?
that's what I wanted to say much on that minute. There's much more to speak on that. That's what I just wanted to invite my lord's attention to the synopsis. My lord could kindly see the synopsis. I'll just take 5 minutes of my lord's time. I have given all the documents. I can divide this into 3 parts. The serial number 1, 2 are the relationship between the appellant and the landlords. Then 3, I said, I am also a property developer. Then 4, 25, 1 appellant and the first respondent, that's the respondent, enter into development management services agreement. Then on 28/9/17.
Just a second. So this agreement, owners are also party,
No, my lord.
not parties.
They had ratified subsequently. That's what I wanted. Yes, but there. On 28/9/17, GPA came to be amended. Appellant and the landlord entered into addendum.
Correct.
That's what. And now, my lord posed a specific question regarding arbitration. Please see that, I will take your worship to that. I had given this spiral book, that's my lord has. Yes. There, all the documents are there, Page 50, Page 55 in that spiral book. (52), they are referred to in, he is referred to as a developer and I am referred to as a development manager. Please see that. That becomes relevant. Now please turn to page 70.
You are referred to as?
I am referred to as development manager, Mondo Builders Millers. About, in the first paragraph is the ND developers. He is a developer, all in capital letters. In the second, and Mondo Builders Millers.
50,
Page 52 minutes.
52.
It starts at 50, 52 is relevant. I am referred to as development manager.
Yes.
Now please turn to page 70. It's class 16, termination of services. Development manager alone shall have the right. That is, my client alone has the right to terminate this agreement if the developer has committed any breach. Then 17.2. Same page. Any termination of this agreement under class 16 or 18 hereof shall not prejudice or affect accrued rights or claims of either party to this agreement. Then please see 17.4. No remedy referred to in this class 18 or in any class of this agreement is intended to be exclusive, but each shall be cumulative. Then arbitration clause. So therefore, he has no power to cancel at all.
Understood.
Yes. Then
Just a second, you admit the fact that this dispute is arbitrable.
No. 17.4.
Agreement provides for arbitration.
No, 17.4. That's what I said.
What is the implication?
No remedy referred to in this class 18 or in class agreement is intended to be exclusive. It is not the only arbitration. We can go for civil dispute also. And in this regard, we have also filed.
For 18 is arbitration, all right.
Arbitration is 18. And in addition to any other legal remedy referred to above, otherwise available to either party.
What I'm trying to say is,
Please.
arbitration is also permissible if you are saying yes.
Yes.
So this dispute is arbitrable. You can also go to civil court.
We
That's
can
your contention.
also go, not, it is the only thing that's.
Understood.
Yes, please.
You have provided 2 remedies. One is arbitration, another is regular suit.
Regular suit.
Now, if you are saying that The completion, if it takes around 6 months or whatever, you can make a statement. Till then, you can't sell the property, right? Till then, you can make a statement, you can go to civil court or arbitrator, whatever you suits you.
I mean, like, so far as the finding of the learned trial judge on arbitration, because that issue has been answered against me. I also preferred an appeal, that's to be listed before your lordship. Yesterday it was before the honorable registrar, that has to be listed because we have questioned that itself.
You have questioned the order appointing the arbitrator.
Yeah, no, order holding that the,
Dispute
yes,
is
issue
arbitrary.
number 1 has been answered against.
All right, understood.
We have also filed an appeal. And then Miller, please. And then please, last Miller.
Then let both the case be listed together.
Fine, no problem.
One more appeal is also pending arising from the same order. He says he has also filed an appeal because
I have also filed an appeal.
his contention is the dispute is not arbitrable. He's referring to.
We'll have a copy on Mr.
The answer to the appeal which is filed by them.
Both cases be listed.
Both can be taken up together. Tuesday or Wednesday, subject to not.
Except on 2nd and 4th.
No, what we are thinking is, see, answering all these legal contentions, we giving a finding that's a different story. Ultimately, you're on interim measure now.
That's the reason, Lord, I just cut it short and say this. They are claiming that they are the power of attorney. I said that they should not act upon the power of attorney and sell the properties. And the court refuses to grant this order. After the application was filed and till the date of the order, I have produced documents to show that they have been selling the properties. Now,
Before it is developed,
yes, yes. Now the question is, even if it is to be said that this is an agency coupled with interest, it is a matter which is required to be decided during the course of the arbitration proceedings at the most. Till such time, there cannot be, dilution of the property. That is the well-settled position of law. That's all what I am asking.
there cannot be much dispute over the fact that this is an agency coupled with interest.
And one more submission.
That whether it is agency coupled with interest or not, that is a disputable question. If the court wants to decide at this stage, I will assist your lordship to demonstrate that this is not an agency coupled with interest.
Well, that very issue is before the learned single judge, in the form of a writ petition. That's also there. Where the interim order is there and they are aware of it.
The matter, because this is the
Oh,
matter
that
where-
issue is also there.
No, just a second. Have you
Because
filed?
against the
No,
cancellation, we have filed a writ petition.
just a second. You have filed an appeal against the very same order, which is
It is
influent
the
here.
same order.
And he has filed an appeal against the injunction granted by the commercial court.
Injunction which is refused by the commercial.
Refused by the
It is not
commercial.
Refused.
No, he has obtained injunction.
No. Original suit.
Original suit,
Earlier, there was a original suit filed by him.
but
In
in
the
the,
suit, there is already a decision given that this is an arbitration which is required to be filed. Section 8 application has been written and it is said that the parties are to be relegated to arbitration. Now, one of the grounds on which the instant order is passed is that I should have disclosed the fact that he had already filed a civil suit. I was not even notified as on the date when I had filed the application.
That's what he said.
That's
Let both cases be listed together.
because my learned senior friend says it is not possible on 2nd and 4th. It is not otherwise inconvenient to the court.
Third may not be.
5th,
And third, we've listed all the RFA matters. And
5th,
fifth,
we'll give a copy.
List alone.
Sir, other than
number could be.
Sorry, what is the, is it an appeal only commercial appeal?
Yes, commercial. We'll give a copy to him.
Okay, number.
Yeah, we'll give the number.
We'll give the number.
Great.
Nagendra Nayakar.
Used.
Hello, yeah. Hi, you're busy? No, tell quickly. Nothing.
Twenty-four.
Okay. Regularization.
It is now, it is stayed, recovery state.
So far as the refund is.
The case will. Thing is, 7 point, he has been regularized. Retrospective effect was given for his promotion. 32 was placed, for that 7.5% was given. Entire thing was settled, my lord. The difference was 7.5% which was given till 2020. He was retrospectively given effect to 2013, the promotion was acted upon. Retrospective effect was given. For difference amount that. Yes.
Rafiq Masih.
Serial number 35.
He has succeeded on Rafiq Masih before tribunal, my lord, then it's, I don't think he should have any grievance. None of us have succeeded, only he has succeeded with that. That's the. They are right now.
Please give a look at the listings and give.
Lord,
us.
serial number
Serial number
31, my lords. Lords, on the date of promotion, no articles or charges were issued. Articles and charges were issued after 6 months. Since even then, my promotion is not considered covered by the decision. Short, very short.
Serial number 35 also, my lords, it is covered by judgment for having passed the Kannada language examination, my lord. Additional increment has not been granted, my lord. That's the only. It is covered by coordinate bench of this honorable.
Please list it on.
Please, they have also furnished that copy, my lord.
It's-
And another one is
Because
20.
of cases, the difficulty is if we list cases which we are not likely to be able to take up, that
Yes,
also creates a difficulty. That doesn't seem to be happening.
And serial number 29, my lords. Fourth, my lord. Fourth. Great.